be chairing this, I think, very interesting session on how the EPPO is working. So after more than 20 years talking about what the EPPO should be, how it should look like, and just thinking or hoping someday it will be a reality. Now we are there. And we are there with an excellent panel that know what is going on and what is behind the rules, and not that they are not complying the rules, but how the rules are being applied, and they are creating also the rules, the internal rules of procedure, which will be obviously essential in the day-to-day handling of the work and then the success of the EPPO. So I will stop here. I only want to say that I'm very much honored to be chairing this, and I'm very much looking forward to learn from all of you what is going on. Because I remember in 2002, when I wrote a proposal for a project I carried out in Germany. So it's 20 years ago. Yes, we are getting older. But my proposal was if and whether the European Public Prosecutor's Office at that time, so remember, 20 years ago, we didn't even expect to have, or we didn't know if it would be real to have this institution be put in place. My proposal was beyond investigating and handling economic crime, anti-fraud institution, if the EPPO should also spread its competences beyond to other supranational interests in a more effective cooperation in the European Union in fighting other supranational interests. So we are not there yet, and that will be the next step for academics. But now it's the moment to listen to the interventions of the presenters, the speakers of today. I will make a very short introduction of all of you. So obviously, you know all of them, and they all have a very broad professional background. And I will first give the word. I think we changed a little bit the order. So Luca De Mattei is talking first. Am I right? So Luca De Mattei is the head of the legal department right now at the EPPO. He's magistrate with a long career in Italy, and we haven't structured with titles and precise topics this panel so that the discussions flow in a more flexible and spontaneous way, so that we really address the questions they are as crucial right now in the working of the EPPO. So, but anyhow, they have coordinated themselves, and we are very eager to listen to you. So, Luca, the floor is yours, and thank you.
Thank you, Lorena. Buongiorno a tutti.
Good morning, everyone. I'd like to thank the Fondazione Basso for its invitation and this wonderful hospitality and this setting, and for the opportunity to deal with these themes, which are especially important to all of us and crucial to us. I will continue in English, but I wanted to specifically express my thanks to the Foundation.
Done internally, I ended up speaking first because what I would like to do is get out of the way, and leave you in the company of our European prosecutors first, and then of Nicolas later, to give you the feel of what it's like to be on the road with the EPPO, meddling in the real substance of what we do. I coordinate the legal service of the EPPO. Our function within the EPPO, legal service and an organization of lawyers, seems like a bit of an odd construction. However, we have the task of assisting the decision-making bodies in the EPPO, college, permanent chambers, European prosecutors, in the interpretation of the legal framework which applies to our work, in particular the legal framework under EU law. It's being understood that for the interpretation of the national framework, the European prosecutors and the deputy prosecutors are the ones best placed to do this activity, and they do not need our support. What doesn't change the fact that because of the situation that you have been described yesterday, in particular for the relevance of national law in respect of the EPPO's operative work, which is predominant, we are sometimes confronted with the need to understand how each of the 22 legal systems from a procedural and substantive criminal law point of view work, because otherwise applying the rules which do pertain to the European law parts of our legal framework becomes very difficult. I'll give you perhaps an example later. So I want to speak very briefly just to give you a feel of how in this first years of existence of the EPPO, and in particular in this first 100, by now almost 120 days of operations, our legal framework has resisted the impact of reality and of the operative work of the EPPO. What is our legal framework? Well, our legal framework, of course, starts most obviously with the EPPO regulation, which is proving to be an incredibly complex piece of legislation to interpret, with questions, quite fundamental questions arising at every turn of our work, including few issues which I would like to give to you as questions as we have received them, discussed them internally, arrived at some possible provisional conclusions on which action has been taken or will be taken, and that of course remain to be tested against the reality of the ground, of the courts, and ultimately of course against the interpretation that eventually the Court of Justice will give of these concepts. One of which being the question whether the EPPO regulation allows an autonomous definition of what the power and role of a prosecutor is, or whether our European delegated prosecutors and the European prosecutors, when they act in their national systems with the power of prosecutors, are merely replicas of the sets of powers and competences that their national counterparts have. Does the EPPO regulation in particular give the European delegated prosecutor a minimum set of tasks and responsibilities that all of them have to have regardless of the legal system in which they carry out their work? What of course is a question of enormous relevance, considering the wide divergence between the legal systems in which our activity is carried out, where you have systems where the prosecutor is the center of the investigative activity, and others where this stage is shared with other actors, such as investigating judges. So is there in the EPPO regulation something that warrants a minimum common denominator to the activity of the delegated prosecutor, regardless of these differences? One of the concepts that has been most prominent in terms of the need to interpret it and to give this interpretation a meaning in terms of practical application is the concept of the single office. In particular, the questions can be summarized to a main fundamental overarching one, which is when does the EPPO regulation, apart from obvious cases where this is spelled out clearly, not many really, require attribution of specific tasks and responsibilities to one organ of the EPPO rather than to another? Is there a situation where the organs of the EPPO are interchangeable when this is warranted by the need to conserve the useful effect of the regulation? And in this respect, every time that the regulation speaks of the EPPO doing something, the question arises, yes, but the EPPO who? Questions the role of the supervising European prosecutor. there's a number of issues where the EPPO regulation is either silent or vague. What is the exact boundary of the role of the supervising European prosecutor when he or she takes over the running of an investigation according to Article 28.4 of the regulation? Is that role limited to investigations, so does it extend into other segments of the life of a criminal affair? What is the role of the supervising EP vis-a-vis the delegated prosecutors? How does this role, how is this role reconstructed? Is it a hierarchical role or is there a functional division? What is the role of the supervising EP vis-a-vis the permanent chambers? Is it necessary that the supervising EP is always external to the permanent chamber in their decision-making process, strictly within the limits of the powers of the voting powers established by Article 10.9? All these questions have been asked and some answers have been given, but again, I pose them to you in terms of questions because I think it's more useful for what we're doing today. We've spoken at length yesterday about competence. I'm not going to take that up again now because it has been, I think, debated long enough, but questions. What is the role of national criminal law in the definition of EPPO's competence? In particular, what is the space for the application of rules of national law in defining what is a conduct in terms of definition of EPPO's competence? What is the role of national law in defining what it means for an offense to have been committed in the territory of a member state? All these questions I pose to you as food for thought, and I'm not here to provide answers. The legal framework continues, of course, with the offshoots of the EPPO regulation in the internal rules of procedure, fundamental document which the college approved at the very beginning of its activity 1 year ago, where based on this question and others, a number of assumptions were made and a number of, shall we say, philosophical preconditions were transformed into concrete rules. First of all, if you read the internal rules of procedure, they're online on our website in all languages. You will see that there is a rightful preoccupation with business continuity. The idea that the temporary impediment of one of the organs of the EPPO shouldn't stand in the way of the EPPO performing its task, based again on the concept of the EPPO as a single office. One of these rules, just to give you one example, concerns the absence of a member of a permanent chamber when a decision has to be taken as a matter of urgency. And the decision of the college in this case has been based on a concept which is, if you will, more inspired by administrative law than by criminal law. That's the absence of one member of the permanent chamber, not the supervising European prosecutor, who by virtue of the regulation always has to participate in the deliberations of the permanent chamber, does not prevent the permanent chamber, in exceptional circumstances and when it's not possible to delay the decision, to take a decision if that decision is taken unanimously, applying a principle of administrative law of what we call in Italian la prova di resistenza, to verify that the presence of another European prosecutor could not have altered in terms of vote the outcome of the decision of that permanent chamber. The internal rules of procedure have given body and substance to the rules on allocation of cases based on a number of principles which are not self-evident from the EPPO regulation. The permanent chambers are tasked with following investigations and prosecutions, taking key decisions. Does that mean that there is a sort of, how can we say it, prosecutorial equivalent of the principle of the natural judge? In that the permanent chambers have a necessary link to an affair which is attributed to them based on rules which are predetermined, foreseeable in terms of their application. It's not necessarily so, but what you will read in the internal rules of procedure is, first of all, the preoccupation to ensure transparency in the attribution of affairs to the permanent chambers via a system of purely random allocation. Second, the fact that this, once established, this allocation has to be stable. Which means that a permanent chamber should not be deprived of its supervision of a case unless there are very specific reasons to do so. And this, of course, has on the one hand a underlying very pragmatic reason of efficiency, because once 3 European prosecutors have gotten to rights with the substance of an investigation, they shouldn't be forced to give it up, and for 3 of their colleagues in another permanent chamber to start from scratch. But there's also, of course, here a question of accountability, in the sense of ensuring that because of this need of transparency, there should never be the impression that an affair is taken away from the supervision of a permanent chamber for purely occasional or less noble motivations, such as the disagreement with the orientation that the permanent chamber may have on the handling of a case, and so on and so forth. The other piece of legislation that of EU law that we are trying to help the other organs of the EPPO interpret is, of course, the PIF directive. And here I'm not going to dwell long. You've heard enough yesterday. One example that I would like to give of this activity concerns the type of experience you get on the ground, which is essential to actually evaluate concretely how this type of EU instrument works. I'll give you one example that we've had to address at quite some length concerning a member state where the literal transposition of the PIF directive seemed to leave no room for doubt or reprimand to that member state in terms of compliance with their obligations. However, the practice on the ground and the application of these rules by the courts showed a sort of malicious compliance, in that the letter of the law is systematically applied in such a way as to render the criminal law provisions on repression of certain types of fraud inapplicable. And reconstructing this and reconstructing the reasons why this is possible within the framework of the obligations provided by the PIF directive is something that was necessary to allow the delegated prosecutor colleagues in that member states to try and address possible remedies to that situation, and that, of course, will ultimately feed into the dialogue which is ongoing between the EPPO and the Commission in order to help the Commission do its job of ensuring that the obligations under EU law are respected. There are other less evident pieces of EU law which are relevant to our work. That again, as legal service, we try to introduce and support in terms of their interpretation. They're less evident and perhaps don't concern so much criminal law. But for instance, we have had to come to rights with the application of the computation of time regulation, old regulation of the European Communities, which establishes the rules applicable to how you calculate terms and deadlines when they're established under EU law. So it may seem like a trivial matter, but take the provision on evocation with its punitive deadlines introduced by the legislator, which needs to be interpreted in terms of what it means for the EPPO to be able to assess and exercise its prerogatives under Article 27 of the regulation. The application of regulation, again, something old but always very important. Regulation number 1 of 1958 on the use of languages. Now, what does it mean for the EPPO to be a EU institution and therefore to be bound by regulation number 1, 1958, which prescribes in dealings with member states and their authorities and citizens the use of the official language of that member state? What does it mean for an authority that inherently as its core business that of dealing with those authorities in terms of criminal procedures? What does it mean in terms of language of those procedures, of production, of the procedural acts of the EPPO? So just to give you a flavor of the type, the variety and the scope of the area of EU law that we at the central level of the EPPO help to interpret. And we haven't even touched upon the national law. I hope the staggering complexity of the system shines through this very short description. I close. We have, as I said, provided some initial thinking. Occasions like this are precious to have a first test as to whether our initial thinking has any reason to hold up. And of course, we are ready, we're braced for the impact with what the courts of the member states and the Court of Justice will say. With a final reflection, I think one concept that we as EPPO will have to stress very strongly when we will start dealing in a more structured manner with the courts is that when we do go before the courts of the member states, those courts are, as it's self-evident to those that study EU law, but perhaps it's worth repeating it. Those courts will be also at the same time national and European judges, because they will be called to apply European law. And it will be our task to provoke what has been yesterday recalled as that reflex communautaire for these judges to apply this legal framework in a loyal manner and in such a manner to bring to the table a virtuous dialogue between courts that will ultimately help clarify this complicated legal framework. I will stop here and leave you to the fun part with the people on the ground.
So thank you very much, Luca, for these preliminary words and very good introduction. Just mapping some of the complexities. We will be the next years discussing and talking and having an eye on what is going on in the EPPO, because for academics it's also a very, very fruitful research area. And obviously there are so many pending issues from the procedural point of view, but I would like to underline one point, that the EPPO will work well if you really do a good work, but this is just an institution within a broader system. And if law enforcement in the relevant member states does not cooperate correctly, and the other way around, rule of law and independence, judicial independence is one of the core elements just to make this institution also work efficiently. And I want to give the word right now to Danilo Ceccarelli, who is right now the Deputy Chief Prosecutor in the EPPO. So welcome, Mr. Ceccarelli, or Danilo. And it's Danilo. It's a pleasure to have you here. Danilo has been magistrate in Italy since 1995 and has a wide career and experienced work in fighting and prosecuting financial crime, tax fraud, corruption, and organized crime, and money laundering. So he has been also international prosecutor in Kosovo, and in transnational financial crime and corruption and international cooperation in the prosecution office in Milan. And I'll stop here reading and informing you about the long and lengthy CV, which is impressive, of Danilo in fighting economic crime, corruption, and obviously transnational crime. So please, Danilo, the word is yours.
Thanks, Gloria. Yeah, thanks a lot, Fondazione Basso, for inviting us. I remember when we were first contacted by Fondazione Basso, it was a year and a half ago, and we had not even been appointed. It was like, right, I don't know yet what's going to happen, if we will be appointed, when we will start working, how we will start working. And what are we going to do at the beginning? Are we going to set up the office or start operations immediately? When are we going to open investigation number 1? And now we know that day has happened. On 1st of June 2021, we opened case number 1 of the EPPO, which is a German case, just for your information. Well, it's been a tough period. It's been tough months here. I'm going to talk now mainly about how I, as a supervising European prosecutor for Italy now, I will talk about the general picture, maybe general problems later in the second tour. In Italy, what are the difficulties? What have been the difficulties in setting up the office, and what are the difficulties now? What are the main complex legal and organizational issues, and how we are trying to deal with it? We have today an ADP from the office of Rome and is very well aware what I'm going to say now. I have to say, Italy was not ready, really was not ready when we started working. We were appointed last September 2020, and there were a few countries, really a few countries that were ready, that had already started the selection procedure for the ADPs, that had identified the offices for the ADPs, that have identified competent courts. Okay, Italy was not the only member state that was delaying so much the preparation of the PPO. There were a lot of other member states like that. But the complexity of the architecture of the Italian judiciary made everything so difficult and so complicated. And you can understand why. There was this process of approving the implementation law. It's not really an implementation law because the regulation applies automatically. It's a regulation. But all the member states needed some kind of legislation to adapt their own system to the regulation, because the regulation having immediate and direct effect on the powers of the judiciary in the member state, of the powers of the prosecutor, on systematic provisions of the criminal procedural code that had to be adapted to the regulation, needed to approve a legislation adopting the internal system to the regulation. This was a long negotiation and very complex. And we have decree number 9 of 2021 that we all know. This is the Italian law about the EPPO. And following that, I remember immediately after those times, the government fell, and there was a change in the Ministry of Justice. That didn't help speeding up the procedure, of course. But then, with the new minister, everything was resumed very quickly. But it was already very late, because we were about to start operations on the 1st of June. So in 2 months, 3 months, we had to select the ADPs, identify the physical offices, identify the support staff for the Italian offices of the ADP, entering the agreement with the EPPO about the number, the territorial distribution of the ADPs. You are certainly aware that it was decided and it was agreed to have in Italy a very fragmented organization of the office of the ADPs. 9 different offices. This is the only member state that has such a fragmented organization. I really envy member states like France or Spain that have just one office for the ADP and one competent court. Everything is done in Paris or Madrid. How much easier is that for us? And I also envy member states like Germany that, when we started already, had identified 5 centers for the ADPs and had already concentrated the competence of the court as much as possible, which means in the states, in the federal states, only 16 courts are competent for the PIF crimes. Here today, we have 140 competent courts. We have to travel the country. The ADPs have to travel the country to go to court. But not only that, I mean, the situation is so difficult that even during the investigation, they have a judge, the preliminary investigation judge, scattered in 140 different small tribunals. That is making our life really tough. You can understand what that means every time you have to ask for an authorization, for a freezing, for an investigation measure, for an interception. In an architecture where, for example, the interceptions are regulated by very specific laws, with an archive of the data that is controlled and under the authority of the local chief prosecutor. They control and they have possession of the archive of our data, of the data of the EPPO. This is a consequence of the complexity of this architecture, but also of the hybrid nature of the peripheral office of the EPPO. Even think about the status of the ADP that fully belong to the PPO. They are hired by us, nominated by us, paid by us. But all the support staff, the administrative support staff, the police, the offices, all the material resources are given to us by the member states. So we depend on them. We really depend on them. Now, I have to say that in Italy, I found a very cooperative approach. If we put apart the fact that it was very much delayed, then when we started cooperating, it was a very good cooperation. You will see it's not like that in all the member states. We get to situations like Slovenia where we have open boycotting, refusing to give us the name of the EDPs. And then we are paralyzed there. In Italy, we work well, actually. We are working very well. Cases are flowing in. We are already very much operative pretty much everywhere. It's a pity we could not appoint ADPs in 5 ADPs so far. It's just 15 out of 20, but hopefully the High Council will, will issue a new call. The High Council of the Judiciary. It's another element of complexity. Every time we have to go to the ministry and to discuss issues, there was always the ghost of the High Council around the corner, right? They have to be involved. That's the balance, the constitutional balance of the judiciary in Italy, even when it's about only prosecution, of course. Every agreement between the EPPO and the national authority is an agreement with 2 national authorities, the ministry and High Council. The territorial distribution of the EDP, their functions has been approved by the ministry and by the High Council. Every time we talk to them and we deal with them, we have to take in consideration 2 different authorities, at least. But then a lot of burden have been put on the prosecutor's office that are hosting us, right? Because we work integrated, although we are totally independent, we are a totally different office. We cannot receive any kind of instruction. We cannot receive any kind of order. We cannot be coordinated by the National Anti-Mafia Directorate, for example, which is the reason why we enter a working arrangement with them, a working agreement to cooperate and exchange information, if needs be, on a peer-to-peer basis. Because you will see, we deal with cases that fall into the competence of the Anti-Mafia District Prosecutor's Office. They are pretty much involved in PIF offenses. We'll see a couple of specific cases. So, but then the gist of our cooperation, our institutional counterparts, most of the day of our operational life are, on one side, police forces and prosecutors' offices, all the prosecutors' offices, 140 prosecutors' offices we have to deal with. And they are supposed, each of them is supposed to send to us information for possible evocation. We've been working very hard. I mean, like the ADPs have been traveling to different places to talk to colleagues, to educate them about the EPPO, to tell them who we are, what we are doing, what is our role, and what is their role in towards us. We counted, I mean, like at the central level of the EPPO, we counted in the regulation 24 situations where there is a mandatory consultation, exchange of information between the central office of the EPPO and the office of the ADPs and the National Prosecution Service. And this is what is mandatory, because then there is a lot more. Yesterday, someone talked about, well, we all talked about conflict of competence or contrast of competence. And Lorenzo said something which is, I mean, I couldn't agree more with that. If we want to avoid the conflict, we need to talk in advance. We need to communicate. We need to exchange ideas. We need to understand each other. And that we are really doing that. I mean, I think the IDPs are most of the time on the phone with colleagues to try and understand how to exchange information. What is in the case file? Is this my competence? Is this your competence? Can we split it? Can we work together? What can we do? And so far, we avoided any hint of possible conflict. It's only 4 months, okay? We are really at the beginning, so we will see. There will be conflicts in the future, without a doubt. But so far, this has gone very well. This policy of talking, of communication, of having informal communication, and then the formal one, of course, when it's the right time to do that. So this is a work that has been done for the last year and is still ongoing. I think it will never end, actually, because on one side, setting up such a complex institution like a European prosecutor's office with direct powers in the 22 member states, well, that's a never-ending process. But the interaction with the local prosecutor's office, well, that will never end as well. It's in the regulation. It's every case has to be reassessed continuously by them and by us to see whether the competence shifts in their favor, in our favor. And so we have to exchange the communication and see if there is room for a referral, for the evocation on one side. So it's a very long process that requires a lot of liaising with and dealing with the counterparts. I mean, one of the things that when we were discussing the number of the ADPs in Italy, how many, there were some criteria according to which there should have been over 30 ADPs in Italy. But according to our domestic criteria, where the prosecutors are very much charged with a lot of cases, there should have been a lot fewer, right? So that was a compromise in the end. But what was really not understood, and maybe now it's being understood, is that the work of the ADPs is very much different from the work of the usual domestic prosecutor. They have a ton of additional tasks. I mean, the way they have to work on also the IT part of their job. Okay, everybody is using the domestic case management system, GPR, GNR. Well, they have to use that and the EPPO one, the EPPO case management systems that has totally different rules, a totally different architecture that require a lot of education, a lot of training, and at the same time in the domestic. And you know what? The supporting staff, the administrative staff, of course, they can access the domestic case management system. They cannot access the EPPO case management system because they are not staff of the PPO, and the regulation prohibits the supporting staff even to touch a computer of the EPPO, a European computer with the case management system. So the ADPs work on the EPPO case management system with the central staff of the EPPO in Luxembourg. And how much time do you spend on the phone, Alberto, every day with them? That's really a different job. And then you have to undertake the investigation and go to court. We've done it. We already have a lot of freezing and seizures and confiscation, and we have a very good record with that. We really want to recover assets that the EU is defrauded. And then there is the legal issue, because it's not only organizational, it's not only about the architecture and the structure, there are the legal issues. What are the main issues, at least in Italy, but I would say in the other member states as well? the big unknown, undiscussed, and almost silent core offense of the EPPO that in the member states, at least in Italy, was totally underestimated is smuggling and import VAT offenses. And this is really something very, very sensitive. We have, and to a great extent, it depends on the regulation. The regulation on Article 25, basically. 25, paragraph 3, and paragraph 4. The regulation is a structure where you set a rule, then you set an exception, then you set two sub-exceptions to the first exception, and there is also a possibility to make an exception to one of those sub-exceptions. That's how Article 25 works. Just read it, one paragraph after the other, you get mad reading that, right? So what we have there, we have a rule that we can exercise the competence for PIF offenses if it's, let's say, above 10,000 euros damaged. Then, if there is an interlinked offense, we can exercise the competence if the other offense is instrumental to the PIF offense. Otherwise, we can exercise the offense only if the PIF offense is more serious than the non-PIF offense. Careful, more serious, because if the maximum penalty is the same, the case goes to the national authority. But in Italy, we have a system where, in order to understand if a penalty is more serious, we consider the maximum and the minimum. The regulation doesn't say anything about that. It's only the maximum, right? So there we have smuggling, excises, which is a different offense when it comes to petrol and alcohol. So we have to, it's the same action, but it's two different offenses. So we have to understand which one is more serious. And then we have the import VAT offense, which is very old and bizarre the way it's written, Article 70 of Decree 633 of 1973. It's almost 50 years that this article is there, completely ignored by most of the colleagues, right? Because never been applied. Now for us, it's becoming a big thing. And the legislation on the PIF directive completely forgot this crime. Completely forgot that this offense exists, and if it involves two member states and it's above 10 million, it's a PIF offense. We have fraudulent schemes with the abuse of Custom Procedure 42, which from Olaf you know very well, and these are massive frauds. We have frauds with damage of 20, 30, 50 million VAT evaded. Very common, usually from Eastern Asia. They smuggle. Actually, it's not even smuggled. It's entered with this custom procedure, with the provisional import, and then the goods vanish and nobody pays the VAT. They are distributed in different member states. Everything, the VAT is lost. It's a big loss for the member states. You know, VAT is only for a small percentage a resource of the EU, but that's the member states that lose a lot of money there. And nobody is really fighting that. And now for us, this becomes a priority. And in Italy, we have a big problem because that offense, and as regards sanctions, makes reference to the law on smuggling. It doesn't say anything about the import VAT in itself. So we have like an asymmetric situation where we have these different offenses, and we have to see which one is the most serious. And in Italy, fortunately, the smuggling offense in the aggravated case, which is always the case for us, is the most serious. We can exercise the competence there. But then you have tobacco smuggling. Tobacco smuggling, there is no special provision for the excise, and so you have the custom fee and the excise in the same criminal provision, and there it's 23, paragraph 25, paragraph 3, letter B that applies, which means that you have to go and see who, where the most serious damage was done, which is the victim that had the most serious damage. So it's a totally different criteria, because it doesn't matter if you have an offense with a very low punishment. If the damage is higher, so the case goes to the national authority or to the European authority, to the EPPO. So it's a very different criteria, right? And for tobacco smuggling, we have that case, that situation. So can we exercise the competence for tobacco smuggling? Yes, but if we apply the exception of the sub-exception, which is paragraph 4, with the consent of the national authority, right? That's what we can do, and that's what we are doing, because colleagues understand that we are in a better position to investigate here. It's happening now. We never had so far a denial. Always had an agreement to take over the case. But who is the national authority in a position to give us the agreement? Is it the local prosecutors that is already dealing with the case or that seized the tobacco? No, it's the General Prosecutor Office at the Court of Cassation. So every time we have to ask them to give us the consent to take over the case, wait for the decision, and then we can exercise the competence. So this is like so complex and somehow so bureaucratic. And these two crimes were so forgotten that there is a quite blatant violation of the fifth directive for smuggling, because the Italian legislature, forgot to foresee the value confiscation for smuggling. We don't have that. Although it's mandatory in the fifth directive, because the fifth directive makes reference to the directive on the mutual recognition of freezing and confiscation that makes that kind of confiscation mandatory. We have, it's a paradox. We have, for smuggling, we can apply the extended confiscation, which is a punishment much more serious than the value confiscation, but we cannot apply the value confiscation. And the same goes for import VAT. And for import VAT, we don't even have a special provision for cases where damage is above 10 million, which is mandatory. Again, we need a punishment above 4 years and a lot of other requirements that are in the PIF directive. So we are fighting with this. We are fighting with all these problems every day. And this requires us to go to the Commission, to the Ministry of Justice, to inform them about this problem and this other problem, this organizational problem, this legal problem. It's a very different job from what we used to do until a few months ago. It requires a different set of skills. It's not the traditional prosecutor or the traditional chief prosecutor or deputy that coordinates and overlook the investigation. It's very decent for this reason. And then also for the fact that there is all the work that we have to do at the central office, that I have to do at the central office as a supervising EP, but also as a component of the permanent chamber and as someone who is involved in handling the case management system and the management of the office. So that's a quite complex architecture. Now, my colleagues will talk to you also about this, but I mean, this is just to give you a gist of the set of problems that we are facing now. I would leave the floor to my colleagues to talk about their own experience before we go back for a second round.
Thank you very much, Danilo. Thank you for familiarizing us with the real work you're doing and facing every day. So we wish you only a lot of energy, because you will need it, of course. We will leave the discussion for later. I go directly to giving the floor to the next speaker, who, according my list, is Ms. Ingrid Marschall-Clausen. So she has worked as deputy to the head of the Austrian Public Prosecutor's Office in fighting corruption and economic crime from 2015 until 2020. So she has also broad experience in this field. And she was appointed before the European prosecutor for Austria. So she has been working already for Eurojust and serving also as justice counselor and head of the justice section of the permanent representation to the European Union. So broad experience in transnational crime, economic crime, and European law. So please, Ingrid, the floor is yours. Thank you.
Thank you very much, Lorena. I've brought some slides, yes, and I've been told that there should be a remote control somewhere here on our desk. Thanks a lot. Thank you. Actually, I've prepared quite a number of slides, but we will not go, don't worry, we will not go in detail into each of them. And I think the first test will be the sort of intelligence test to see whether I will figure out how it's working. Okay. All right. Indeed, may I start by adding my voice to the previous speakers who have already thanked Fondazione Basso for organizing this conference. And I'm very, very grateful that we can have this conference in presence and not remotely, as unfortunately we had to work during the last year and a half with a lot of remote meetings. So I'm very, very grateful to have actually real people sitting around me. It does make a difference, I find. Now, the title of this session is EPPO, How is it working? And actually, the three prosecutors here, Danilo, Thomas, and I, we decided that we would like to shed light together with you on the three different roles that we are performing within the EPPO. First of all, as supervising European prosecutor. Now you've heard already Danilo about his role within the Italian system. Then obviously we have a role to play as permanent members in the permanent chambers, second role. So that would be our second round. And the third role that we are performing is being member of the college of the EPPO. That we will talk about, I think, or at least I will talk a bit about it in the third round. Now, having been myself a former national member at Eurojust, where you also have this collegial structure, this college structure, I am already used to working also within such a setup. And it is true, Danilo, this is a completely different setting and requires completely different tasks from a prosecutor's regular work. Now, how is the EPPO working? So you'll know that we started on the 1st of June and we started, and now it's not working. Hooray! Why is it not working? Please help. Yes. You all know that we started on the 1st of June and we have a bit more than 120 days of operation behind us. So obviously it's way too early to draw real conclusions, but at least we can say that the start was a good one. Statistics, actually, Laura mentioned them. So far, we have registered approximately 2,000 cases since the 1st of June, 2,000 cases. Out of these approximately 2,000 cases, some 1,200 were submitted by public authorities. Out of these 2,000 registered cases, we have taken over, evoked, or initiated some 350 investigations. They are running. And the criminal offenses which are covered by these investigations involve an estimated damage to the EU budget of approximately 4.5 billion euro. And this is the first result of 120 days of operation. That's quite impressive, I would say. So, first experiences in terms of the quality of our work. That was the quantity. Quality of our work. I must say that I found it personally surprising how well we managed to start off. We have already proven that we can properly work as a single office and that we have added value there. We have already, in the cases that we are currently dealing with, and actually one of them was also an Austrian case, discovered that there were parallel investigations ongoing in different member states by prosecutors' offices there, one not knowing that the other one was investigating the same criminal offense, the same facts. So there we do have added value. Cross-border operations, Laura has mentioned them. Actually, we can be fairly quickly in organizing and executing organized measures at the same time, house searches at the same time. Also, we had already successful cooperation cases with non-participating member states, particularly Hungary. I don't know, Danilo, whether you will talk a bit about the external dimension. Yeah, then I'll leave it at that. So then, yes. In the almost a year between our taking up office, which took place in September last year, and the 1st of June, we had to prepare actually for the start of operations. And you have to imagine that actually we are a unique thing, obviously, and there is no precedent. So what we were preparing was based on assumptions. Luca has mentioned the internal rules of procedure. Luca has mentioned, I think, also the conditions of employment for our delegated European prosecutors. And what we have prepared was based on assumptions. It's like trying to learn to swim in a swimming pool where you don't have water. You think you're doing the right thing, you think you're doing the right movements, but only when you actually put the water into the swimming pool, you will understand whether actually you have really trained the right way or whether you don't manage to sink. Now, we have on the 1st of June, actually, the water went into the swimming pool. And we have seen that actually out of the 140 European delegated prosecutors that we should have in this first stage, we have appointed 91, and the 91 which we have are very good ones. They are qualified, they are flexible, and they are able to adjust this to this completely new working environment. We have, by the way, the college has also, in a few cases, refused to appoint persons nominated by member states because actually we thought as a college they would not fulfill the requirements set out in the regulation. We have in the college agreed that we would start with a setup of 15 permanent chambers. We just had to start somewhere, and actually the legal service was very, very, very helpful in developing different models. We were discussing whether we should have specialized chambers, VAT fraud chambers, for instance. But we decided that we would start with no specialization and with 15 permanent chambers who would deal with all cases. We have random allocation of cases to these 15 permanent chambers. Now, there is obviously there will not be an even distribution of the workload of own cases as supervising prosecutor. Now, Danilo will have at some point 20, I believe, European delegated prosecutors. I have 2. Austria will have much less cases to deal with than Italy, for instance. So how can we assure an even workload between the European prosecutors? So we decided, and so far I think the concept is a good one, and the decision was a good one. We have decided that actually the European prosecutors, which presumably who presumably will have many cases to supervise, will be a member of only one permanent chamber, whilst the ones who presumably will have to deal with less cases, such as me, are members of 3 permanent chambers. That is how we started off. But that will also be actually one of the issues and one of the challenges we will have to deal with as an office. We have also, that is also very important for our practical work, agreed on an investigation policy and guidelines on evocation, non-evocation of cases, and case referrals, and we'll come to these later. Yes, some things, however, we're just discovering need to be adjusted. The internal rules of procedure need adjustments here and there, which we discover now that we have started off, now that we're really dealing with practical cases. There have already been revisions of the internal rules of procedure. There will need to be more. The case management system needs to be improved. We have so many legal questions which we have to answer in our daily work. Luca has made reference to some of them. We had the import VAT question already yesterday. We'll go to some more questions in the second round. We have missing EDPs. Slovenia was mentioned. And we need more personnel at the central level. We will need financial analysts. We will need a lot of legal support personnel, particularly for the European prosecutors who will have to supervise many cases. There are some budgetary issues. It's work in progress and continuous learning. Now, coming to Austria, the Austrian setup, my role as supervising European prosecutor. As mentioned, I have 2 EDPs. Both of them have a long experience in dealing with corruption cases and economic crime cases. The 3 of us, we come from the same PPO, the Central Office to Combat Corruption and Economic Crime. Despite the fact that I have only 2 persons, we have this strange construction that one sits in Vienna and one sits in Graz. But they both come from the same PPO, and they both have stayed in their offices embedded in this prosecutor's office, which has a headquarter in Vienna and branch offices in some Austrian cities. And one of these cities is Graz. Now, that complicates our life a little bit because actually we cannot meet in Vienna. So we have to discuss a lot virtually, remotely, but it works. They have 2 administrative assistants. Actually, we have organized ourselves in such a way that we have 2 persons working 50% each in Graz and 2 persons, administrative assistants, working 50% each in Vienna. They can make use of the IT experts, which the Austrian prosecutors' offices, and particularly the office where they are embedded in and where we come from, can use. And there are also economic experts, in-house experts, which they can use, particularly tax experts. That's very, very helpful. The investigations will effectively be conducted by our police, by our customs authorities, by our tax authorities, and I'll come to that in a second. Now, obviously, as we are a small country, our setup is not as complicated as the Italian one, and the obligation for the national authorities, particularly for the prosecutor's office and the head of the prosecutor's office, where both my EDPs are embedded in, stems directly from the regulation and is repeated in the Austrian implementing legislation. We don't need any additional agreements, arrangements. Discussions are very informal, email, phone. So from that point of view, it's good. Also, the cooperation with the team in actually the setup of a team is very good. But there are so many legal issues which we have to resolve, and so many legal questions to which we don't have a straightforward answer. As for cases, almost all the Austrian cases which were already pending before the 1st of June at any Austrian prosecutor's office were submitted to the EPPO. So that obligation has been complied with. We have already found out that there was, in one case, a dual investigation ongoing in Germany and in Austria for the same case, and both countries and both prosecutors' offices weren't aware of that. What we still need to do is we have to promote ourselves and have to get ourselves known towards the police, towards the customs authorities, towards the tax authorities. And why is that so? Because actually the Austrian law to implement the EPPO entered into force on the 30th of May 2021. So there was no time beforehand to prepare. There was no time to prepare also the investigating, then effectively investigating authority that we would be about to start. So this is something still on the to-do list for us. By the way, in Austria, all public authorities, it can be the mayor of a little village, have the obligation to report cases potentially coming under the competence of the EPPO to the EPPO. Many cases will, or many reports will obviously end up at a regular, normal Austrian prosecutor's office because that will not be known to everyone. So our prosecutor's offices at home will be mainly the partners we have to talk to and work with. I should probably also say about cases that just last week we had the first successful operative cooperation with an Austrian prosecutor's office in a case which is dealt with by the EPPO about FFP2 masks. Actually, in Austria, an investigation, and I can talk about it because the case has been in the media. In Austria, an investigation is ongoing because of fraud. These lovely, or similar lovely FFP2 masks having been produced in China, but having been sold in Austria as produced in Austria, good Austrian quality for an Austrian price. And actually turned out that everything, or almost everything, was produced in China, and regular fraud case. There have been several rounds of house searches in that fraud case. Now, obviously, along with the fraud comes the fact that these masks have not been declared properly when imported into the EU. Could not have been, of course, otherwise they would have admitted that they were produced in China. So we have evasion of customs duties. Here the EPPO comes in. And just last week, we had another round of house searches carried out jointly in Austria. Together, the Austrian PPO and one of my EDPs as assisting EDP, and that worked really well. Potential issues and hopes for the future concerning my system. Well, concerning our investigation authorities, we don't have any police judiciaire, but the police reports to the Minister of the Interior as hierarchical superior. Question is, are there tensions? And I would assume yes, with the principle of the independence of the EPPO from the national authorities. We don't have any centralization of the court competencies, also scattered landscape that will be complex. Workload for the EDPs. The number of the two EDPs have been agreed on the basis of estimates of cases. Not included in this estimate of cases are the cases when they will act as assisting EDPs. So we will see how much workload this will create. And I have a personal wish, and I take the opportunity to express this here at this conference. I hope that the EPPO can serve as a role model for the prosecutors' offices in Austria, because they are not independent from the government, they are not independent from political parties, yes, but the Minister of Justice is the ultimate superior of the prosecutors' offices in Austria. We don't have a prosecutor general in Austria. We have a very hierarchical system with a lot of reporting obligations and the right for the Minister of Justice to give instructions in individual cases. And I hope that actually with the EPPO now, having seen daylight, this can serve as a role model and will boost the ongoing discussions in Austria on how to disconnect the prosecutors' offices from the government. Thanks.
Thank you very much, Ingrid, for these insights. I have a good information for you. We have decided to do the coffee break right now and then listen to the next two speakers, because these people promised to talk not more than 10 minutes. But as they are very independent and they are supranational structure, they didn't abide by any hierarchical rules. So we make a 20-minute coffee break if everyone agrees. Thank you very much.
I will have to tell.
So, welcome back again to everyone. And we resumed very interesting presentations on how the EPPO is working. And now we have the pleasure to introduce, I have the pleasure to introduce Mr. Thomas Krusner. And Thomas Krusner is the former chief prosecutor of Criminal Prosecution Department in the General Office in Lithuania. And prior to this, he has been working for the European Commission and in the OLAF. So he has also been working at Eurojust, and he has been a prosecutor since 1998. So it's another very professional piece, I would say, public prosecutor, high-level private public prosecutor in the EPPO. So we are very pleased to have you here. Thomas, the word is yours. Thank you.
Thank you, Lorena, and I also would like to thank organizers for the possibility to join this meeting and Fondazione Basso for following this project in the different stages. I believe it contributes to the further growth of the organization. My colleagues already touched upon different aspects in relation to the functions of the European prosecutor. And primary, we can see those functions both as strategic and operational functions, and those includes functions as a member of the college, as a supervising VP. One interesting aspect is substituting European prosecutor and European prosecutor as a member of the permanent chamber. We also may speak about the specificities of the status of the European prosecutor under applicable national law, which is a case in certain member states. And what are the specifics is the role of the European prosecutor during the setup phase of the European Public Prosecutor's Office, and what is important during this stage, the role of the European prosecutor in relation to the decentralized level and the national authorities. The first meeting of the College of EPPO, so the meeting of European prosecutors, took in the beginning of September last year. And at that time, the EPPO had limited internal legislation, interim premises. I would say limited infrastructure, only the first EPPO staff members, and no European delegated prosecutors. So at that time, the system of working group composed of European prosecutors and EPPO staff was established with dedicated different tasks. And this resulted, I would say, in a number of decisions by the college. So in less than 1 year, the prosecution service started to operate, and it looks like really short period of time, but most probably after a couple of years, we realized what progress was achieved. I would like just to add a couple of comments in relation to, let's say, setup of the decentralized office in my country and Lithuania. And again, so this just to illustrate how the creation of a single office of EPPO was done. So for the moment, we have 4 European delegated prosecutors. So they were appointed in the middle of March, which was good because we had relatively a long time to be prepared for the start of operation, to be familiar with the different legal framework, with new IT tools, and finish their home cases. One prosecutor still continues to act as a national prosecutor, which is another issue which does not allow him 100% work on the EPPO cases. But all in all, we had a successful start. And this successful start resulted that we dealt with the backlog cases in 2 weeks. The precondition for this, I would say, was, let's say, a couple of aspects. Firstly, that National Prosecution Service was proactively involved in the legislative procedure as far as related to amendments with respect to PPO regulation. And really huge work was done when making changes in the internal regulations of the National Prosecution Service. We reached results when making amendments in the national CMS. We have pretty much advanced case management system, which is integrated with all law enforcement institutions, as well with the courts. And now the next step would be just to try to find a way to have interoperability with the EPPO CMS. When I mentioned one aspect related to the status of the European prosecutor, so just maybe practically when we speak about the agenda of the individual European prosecutor, it depends on number of cases dealt by the decentralized office in the respective member states. The number of cases at the permanent chamber in which European prosecutor participates, and what is different is specificities of the applicable national law. And this element involves several dimensions. The first thing that we have really different procedures where for the European prosecutor the different procedural role is established. As example, I can give the Lithuanian criminal procedure code, where European prosecutor acts as a superior prosecutor. It means that it is additional supervision layer with additional tasks in relation to the legality check of the decisions of an individual European delegated prosecutor, considering the complaints from the parties to the procedure up to the end of the pretrial investigation, and even some organizational measures, such as extension of terms of the pretrial investigation. In this way, I would say it somehow correlates to the function of the chambers in relation to the monitoring. What helped a lot before the start of operations is the continuous dialogue with the national authorities. Maybe it's not strictly written in the regulation, but we did a lot when meeting with the national prosecutors, with various ministries, EU bodies, not EU bodies, national authorities responsible for the administering of the EU funds. And in a way, it was marketing of EPPO. Technically, all have to know competencies of EPPO and have to know that the cases have to be reported to EPPO. When it goes to the practical realization, it means that all prosecutors, judges, administering institutions of EU funds have to know what is exactly EPPO competence, which is the way to report, which is the form to report. And as a result of numerous meetings with the territorial offices, with the pretrial investigation institutions, we reached the result, and they know to whom to address the specific countries. And we made, I would say, even additional step, because the priorities related to the competence of the EPPO were established at national level. Recently, a couple of weeks ago, we had the national anti-fraud strategy, where the elements related to the EPPO competence are included. And in this regard, so the national law enforcement is under obligation, let's say, to work proactively in detection and investigation of those cases. Another aspect is that those elements as well were involved in relevant plans at national level concerning to the money laundering programs, where as well we got a piece of European Prosecutor's Office involvement. All in all, third, that now the office consisting of 3 prosecutors, 1 delegated prosecutor is to come, is functioning well. So we have daily dialogue on individual cases, and I would say I was really positively surprised that the workload is increasing. We have incoming new cases, and when compared to the average cases handled by the prosecutor at the Prosecutor General's office, so we reached this level in around 4 months, which in a way is may look at challenge, and as soon as we start working with the proceedings at the courts. So, as Madam Chair proposed to check the independence of the European prosecutor, so I see that I had 10 minutes and 45 seconds, and I believe it shows both, let's say, attempt for the independence and proof of real independence. But as soon as the request was received from academia, I do not treat it as an attempt. Thank you.
Thank you, dear Thomas. Someone told me that you have a very British sense of humor, so, and I realized it right now. And thank you for your generosity, because the time you save is provided for the next speaker. It's not that he will have more time, but he will have his right time. I have the pleasure to introduce right now Nicholas Franzen. And most of you already know Nicholas, and he has been counselor and international coordinator at the Ministry of Justice and Security in the Netherlands, and has wide experience in all issues of European Union criminal laws, and specifically with regard to OLAF and all the EPPO matters, because he was directly involved in the negotiations about the PPO and OLAF regulations. So he has also chaired the GAF, the Group Anti-Fraud and COPEN. So he's a widely expert in these topics, and we are really very much expecting to listen to your presentation. Thank you very much for being here.
Thank you, Lorena. Good morning, everyone. You're setting the standard, you're raising the expectations to a very high level, but I'll try and comply, knowing that it is a challenge to be the last speaker before lunch, of course, even though the number of courses last night will probably postpone the moment where you will actually sense a feeling of imminent starvation, but that was my personal experience anyway. First things first, I'm very, very, very pleased to be back at Fondazione Basso. It's actually the 3rd time that I'm here for a conference on the EPPO. Even though when asked to take part in this particular panel, I initially wondered why me. All of the people here, except you, of course, Madam Chair, actually work for the EPPO, whereas I do not. All I know about its operational work is primarily based on the EPPO's Twitter account, which I follow intensely, and where I noticed that the Guardia di Finanza, as you would expect, is doing an excellent job in line with their perfect reputation. On top of that, it seems early days, as Ingrid said, to draw any conclusions. The EPPO has only been operational for about 4 months. So yes, there are still 49 delegated prosecutors missing and 350 investigations ongoing at the value of 4.6, actually, I think it is, billion. But to my knowledge, it would be impossible anyway. There hasn't been a conviction, let alone a final conviction or a single euro recovered. It's too soon. Then again, I would have probably been prepared to give a presentation about any subject, being able to come to Rome after the pandemic. So I'm happy to be here. Anyway, all joking apart, I'm going to try and contribute to the debate about a serious subject. And I will do so by exploring something, a slightly different perspective to the EPPO's functioning. And the angle for that discussion will be independence and accountability, not or accountability. I have to say this because I work for the ministry. I will express my personal views. That doesn't make them irrelevant, but don't call my minister if you disagree. Let me set the scene a little first before I start. The point of departure, I think, is that no public prosecution service, and the EPPO neither, could expect or would want to function without a degree of accountability and some degree of democratic legitimacy. To be very precise, all that I'm going to say does not concern the treatment of individual cases or judicial control over them. That's a form of accountability, but that's not the issue I will go into today. You may refer to them as policy or administrative matters or budgetary matters or whatever. So I will not be speaking about the EPPO's individual investigations. Now, there's a kind of Bible on the prosecution service. It was drawn up by the Venice Commission in 2011, and it's called European Standards as regards the independence of the judicial system. Much to my joy, in fact, there is a paragraph B, on public accountability of the prosecutor's office. So I haven't invented the concept. That's basically the point I'm trying to make. Looking at point 41, it says, like any state authority, including judges, the prosecutor's office needs to be accountable to the public. And it is important to clear, point 43, what aspects of the prosecutor's work do or do not require to be carried out independently. The crucial element, this point claims, seems to be that the decision whether to prosecute or not should be for the prosecution service alone, and not for the executive or the legislature, which confirms what I said. Keep off individual investigations and prosecutions. I think we all agree on that. So what does the regulation actually say about independence? You'll find this in Article 6. The EPPO shall be independent. That is the main principle, which means that it shall act in the interest of the Union as a whole, as defined by law, and neither seek or take instructions from any person external to the EPPO, any member state, institution, body, office, agency, nobody. Whether this independence was intended to apply to the cases only, I don't know. I don't think it was ever made explicit, but that's the interpretation I give to it now. The independence is to be combined with a degree of accountability, according to the regulation. You'll find this in Article 6, paragraph 2 and 7. The accountability is given form through the obligation on the EPPO to send an annual report on its general activities to the Council, the European Parliament, the Commission, evidently, I should mention the Commission first probably, and national parliaments. The national parliaments were not in the original proposal of the Commission, but were added at the request of the Netherlands, among others, and France and Poland, interestingly. So the EPPO will send this, no doubt, thinking of the reports that Olaf produces, very glossy publication to these institutions, and the chief will then make her appearance to discuss the main findings. She may also be invited to come to hearings at the national parliament, but for some reason which I cannot recall, the regulation allows her to send her deputies. That probably says something about the way the negotiators appreciated the relationship between the EPPO and national parliaments. Okay, it's better than nothing, I suppose. In the third place, there is a provision on the dismissal, the potential dismissal of the European chief, and a similar one on the dismissal of European prosecutors. You'll find this in Articles 14 and 16. The criterion for that is serious misconduct. Just exactly what that actually means remains to be seen. Rumor has it that the college is reflecting on disciplinary rules for the members of the college. So we're looking forward to see them and have some sort of tangible criteria to assess whether such a situation could ever arise. Evidently, that's the point I'm going to try and make, the EPPO does not operate in a vacuum. So I would like to describe the various actors that also operate in that environment and with which the EPPO will have to deal to some extent. First and foremost, that would be the European Commission, of course, to which the EPPO is accountable under Article 6. I think, judging by the experience in the past 2 years or so, we can safely conclude that the Commission is by far the most important partner to the EPPO. And by means of illustration, just look at the working arrangement between the EPPO and the Commission. It comprises no less than 50 pages. So much, in fact, that I haven't ventured out to read all of it because it's very technical, but it says something about the importance of the relationship. There are many administrative links between the EPPO and the Commission, particularly in the budgetary, financial area, human resources, personnel, and even IT. According to the regulation, the Commission has various roles which are relevant to the existence of the EPPO, ranging from anything to the appointment procedure for the European Chief Prosecutor, the drawing up a delegated delegation concerning operational data that the EPPO can treat with or deal with. It would obviously have to draw up a mandate for negotiations with third countries on cooperation agreements, an advocacy decision possibly. So the Commission indirectly has a big role in promoting the efficiency of the EPPO. Let me put it like that. And yet, you've probably seen the article in the EU's Observer of the 17th of September. The Commission has blocked an amount of money, around 7 million, that the EPPO had hoped to spend, but will not be able to, and has therefore returned to the Commission. The second actor I would like to mention, obviously, is the European Parliament. Again, the EPPO is accountable to the European Parliament under Article 6. The European Parliament has had a very prominent role in the appointment of Ms. Kövesi, who is their darling. I think it's safe to say there's a kind of romance between the European Parliament and the current chief prosecutor. The European Parliament does monitor developments, particularly regarding the appointment procedures in some member states, even though I had the feeling that part of that was a national discussion being fought in the European Parliament rather than a major attack on the Commission. And of course, the European Parliament has raised the budgetary issue as well. In fact, just last week on Friday in the Cont Committee, and I'd say the general mood was hallelujah. I mean, I don't think the EPPO will expect much, will have much to fear from the European Parliament so far. They love the EPPO, basically. Then there's the Council. Again, the EPPO being accountable to the Council under Article 6. What in fact happens yesterday even, and this is why Mrs. Kövesi was online at the conference and not here, she would present a state of play, a progress report, and probably say that there are still 49 EDPs missing in action or something along those lines. But there's no real political debate or criticism from the part of the Council on certain aspects of the functioning of the EPPO. So far, anyway. At the lower level, the one at which I operate, among others, the most recent encounter between the EPPO and representatives of member states was in a working group called COPAN, which was on the 16th of April, where we discussed, among others, a note on the expenses incurred by delegated prosecutors. Since then, there have been no more encounters of that type, despite a specific request from the Portuguese presidency to find an opportunity to discuss the recently adopted operational guidelines on investigations, evocation policy, and referral of cases. That was simply rejected by the EPPO. There may be a meeting later this autumn to discuss a recent letter from the college about rules on disciplinary procedures, the one that I just referred to, possibly the EPPO's relations with third countries, but we will see whether that will actually happen. Now, there are two more actors which may be less controversial, I guess. The European Court of Auditors obviously has a role in the discharge procedure. It also has a working arrangement with the EPPO dated the 3rd of September this year. And there's the EDPS. That has several tasks under Chapter 8 of the regulation, whose tasks are referred to in recital 98, if you're interested. The main question, of course, at that point is what will the EDPS's role actually mean in practice? Just looking at the experiences that Europol has, this could be potentially very significant role in the sense that, I don't know if you know about the situation, the EDPS has taken the opinion that Europol has no legal basis to process huge volumes of data, which is essentially what Europol is about. I'm not saying that EDPS will effectively block the work of the EPPO, but it will be interesting to see, to assume what effect it will have on your operations. There may be a tension between the conditions under which criminal procedures take place and data protection requirements, as much as we have tried to separate the two in the regulation, of course. Then there are friends from Olaf, a very important part with a complementary role, as the mantra goes. The Commission had forgotten about them, but under the Dutch presidency, we introduced a provision on cooperation between Olaf and the EPPO and the EPPO regulation, Article 101. The Olaf regulation itself has been revised since to enable this cooperation. And obviously, Olaf also has a working arrangement with the EPPO dated the 5th of July. Even more interesting is a recent college decision of the 30th of June, which concerns the accession of the EPPO to a very old interinstitutional agreement of the 25th of May 1999, and that concerns investigations by Olaf. In other words, if ever there was a reason to think that there were irregularities or even mismanagement within the EPPO, Olaf could step in. Now, suppose that Olaf were to find that something had gone wrong, that there was a reason to start a criminal investigation. An interesting question, of course, would be, who would then do it? Would the EPPO do so itself, or would it leave it to the national authorities? In Luxembourg, I suppose. We'll see. But I don't know, it's very theoretical, but given the fact that Olaf is undertaking investigations in Frontex and Eurojust at the moment, it's not completely hypothetical either. We'll see down the line. Well, then last but not least, and this is where I come in, I suppose, as a representative of one of the 22 member states, the 21st, in fact. We were not very keen to join from the very start, but we did in the end, and we have been very loyal since. According to the regulation, there was an expert group under Article 20, paragraph 4, chaired by the Commission, where we discussed a host of issues ranging from the draft internal rules of procedure to the draft conditions of employment, CMS, case management system, data protection issues, draft budget, which was useful in a sense, even though it wasn't always enjoyable, I have to confess, and Luca will confirm. You attended quite a few of the meetings. Unfortunately, despite repeated promises, the Commission has discontinued this type of meetings once the college was in place, which, strictly speaking, is in line with regulation, but still a missed opportunity, I feel. So what we have now in practice is that there are bilateral contacts between European prosecutors and ministries of justice, and between the EDPs and the national authorities at operational level. But they are very much dependent on the personal style, or if you like, the charisma of the European prosecutor involved. So there's not a single approach to these type of contexts, particularly at the policy level. However, and this is where my concern lies, college decisions may indirectly oblige member states to amend their legislation and face financial implications. I will mention two examples. The first one being the conditions of employment of European delegated prosecutors, and the other one, operational expenses incurred by them. I already referred to that. For me, the problematic part in this is that in both these situations, the college, faced with budgetary limitations, has, I will use a diplomatic term, stretched the regulation in order to legally justify the shifting of the financial burden of these costs to national authorities. Whilst the consequence of that, ironically perhaps, is that it led to ad hoc and unsatisfactory solutions for the EDP's concerns, which in the end became entirely dependent on the goodwill, or if you like, on a more banal level, financial support assistance from the member states, which definitely raises issues in relation to their independence. You can't have it both ways, after all. So if anything, I'm not sure if anyone's taking notes. Any point we need to change in regulation is the status of EDPs. That is clear. Furthermore, I wonder, does the EPPO really wish to convey the message to member states that it doesn't really care about what national budgetary rules are in place, or tell them to just write the check? I don't know. To me, it doesn't seem like the ideal route to win hearts and minds in among national authorities, to be very honest. I generally find it questionable, if not even fundamentally objectionable, that the college, by taking certain decisions it sees fit for whatever reason, could end up exercising a kind of quasi-legislative powers that affect member states, without, at the very least, having consulted them in the process. I mean, I'm not exaggerating. Some member states have actually had to amend their national legislation as a result of these college decisions. I find it dubious from the point of legal underpinning of such decisions and even democratic legitimacy. Again, a number of member states asked the college to be consulted on the very first decision on the conditions of employment, but that request was sadly ignored. Final actor I should mention are the national parliaments. They will also receive the annual report and may invite the chief for a hearing to discuss it, in which case the deputy might appear, as I explained earlier on. But what is the situation in case something goes seriously wrong? I'm asking this from the reality in the Netherlands, where the Minister of Justice is politically responsible for the actions of the Public Prosecution Service, which to some of you may seem odd, but we've actually had ministers having had to resign after controversy about a case that happened many years ago. I'm thinking of a deal with the criminal that didn't go well with Parliament when it was known 13, 14 years later. And the minister at that point actually had to resign because of that. I'm not saying that the minister should, because the EPPO screws up, excuse the expression, but let's take an example. During a house search, the investigative authorities arrest a suspect who has a heart attack or tries to escape through the window, falls down, and dies. In my country, that would lead to question to the minister, how could this happen? How will you prevent it in future? I think there's no such arrangement for the actions that take place under the supervision or authority of the EPPO. And that may create tension at the national level if they take place on the territory of a certain member state, which they will. In conclusion, I would say that the sacrosanct concept of independence should not be interpreted as an absolute one, an exclusive one. Nor the Venice Commission in 2010, nor the court in its jurisprudence on European arrest warrants define independence of judicial authorities in such terms. In fact, I will quote another Council of Europe recommendation, which the College kindly mentioned in its recent letter on the disciplinary rules, its recommendation 2019 on the role of public prosecution in the criminal justice system. Point 12 says, and you'll understand I was happy to find this, public prosecutors should not interfere with the competence of the legislative and the executive powers. There you go. So this concept, not being absolute, should hold, I feel, with the exception that I mentioned at the start. There should be absolutely no interference in individual cases, period. That brings me to the conclusion that the EPPO should not operate in a vacuum on top of Kirchberg, you know, the mountain in Luxembourg. Is it technically a hill? To a Dutch person, this would soon be a mountain. But should operate on Kirchberg. Nor should it wish to realistically expect that its non-operational commandments. You'll forgive me for the biblical analogy, I suspect. I don't want to touch on any religion's feelings here. To be executed one-on-one without at the very least having some sort of contact with the member states affected by them. Another conclusion is that there are very, very strong administrative and budgetary links to the European Commission. So what is the identity the EPP is seeking to have? Is it to be another DG EPPO or something? Or is it a true prosecution service? That's a choice to be made. There is a form of democratic control by the European Parliament, be it that the general attitude in the European Parliament is very benevolent, as I've explained. There might be by national parliaments in the longer run, particularly in situation of incidents like the ones that I have described. There's a very limited role for the Council, hardly one for the group of participating member states, except at the operational level and individually, and in a subordinate role, subordinate to the EPPO. So all of that leads me to the impression that there is a kind of institutional imbalance in combination with a regrettable democratic void at the national level. Is that the end of the story? No. I have an epilogue. And I would say that given the hybrid nature of the EPPO, it would appear very wise if the college were to begin reflecting on a strategy to better involve the group of participating member states in its work. Or put differently, a strategic mistake to approach them with a sense of institutional superiority based on this one-dimensional notion of what independence entails. Let's not forget, and this is not meant to be as a threat, to be very precise. In fact, it was mentioned by Danilo, I think, this morning. The EPPO's effectiveness is, in the end, very much dependent on the assistance of member states. So it would seem highly advisable to treat them as partners rather than as subordinates or the enemy even. I'm not saying that it's happening, I'm just trying to explain the concept that I'm trying to get across. If need be, the Commission can sort out the member states anytime they'd like. If the Commission feels their legislation is not in order or something or incorrect, that's the Commission's role. But I would warn the EPPO to step into that same role. They should be distinguished. I think I can probably tell what the reaction to my plea will be. namely that the regulation does not oblige the college or the EPPO as such to reach out to member states. No, to. And even so, I mean, is there an explicit obligation or prohibition in the regulation to apply common sense? No, there is not. So I hope that the college will take this plea on board at some point, and that it will reach out to the participating member states as a collective at policy level again, rather than through the individual EPs. Being in Rome, we know the concept of divide et impera was invented here. And it is widely applied in the European context, but I'm just saying it may not be very effective. And if the Commission would be happy to facilitate a dialogue, a form of structured contact between the EPPO and member states, fine. Let's call it a forum. The Commission could even chair it, fine. And what's in it for the EPPO or the Commission? What are the likely benefits, in other words? I think quite a few. I think it will help to build trust, to enhance the legitimacy of the EPPO, to ensure support on the Council side anyway, for its budgetary needs. Just remember the Council could have a leverage, could bring leverage in the complicated budget negotiations. It would help in ensuring support in operational matters and other areas. It would definitely help the EPPO to understand the full implication of its decisions for member states. It would facilitate the practical implementation of the obligations under the regulation. It would ensure equal rules and arrangements for all, and thus promote the notion of a single office, rather than the traditional géométrie variable or diversity that the EU is so used to. I think I will leave it there. Thank you.
Thank you very much, Nicolas, for this very much passionate and I think very deep presentation on the concerns on the democratical balances and what is the role of the public prosecutor in a democratic society. And I have a lot to say on that, but I will refrain my tendency to speak too much and take too much the microphone, and now open for discussion. However, I will already try to put my questions just on the table. And if any of the speakers wants to comment on them, because there's so much food for thought, not only food for thought, but pending issues to be addressed. I have only two questions, if you allow me, the audience, just to put my questions first. I have obviously, when starting back on the regulation and before, we see first, I was wondering, and this has connection with what you are talking about, accountability, and accountability is also talking about how you're spending the resources and how efficient you're working, and obviously, despite the difficult position of a public prosecutor in the institutional framework, institutional independence, or the functional independence of each prosecutor, and despite that the Venice Commission already in 2000 and that report in 2011 already said that there is the general trend to improve the independence of the public prosecutors, and the checklist of the rule of law of the Venice Commission has said that there should be granted more autonomy to the public prosecutors. I think the European Public Prosecutor's Office is in line with all those recommendations, just trying to really ensure what is really the main point for its legitimacy to be quite, if not independent in the sense of a judge, at least absolutely free from political interferences, which is what the rule of law requires. No? But as you said, accountability is a cornerstone, and it's the counterbalance of independence or autonomy. And there might be the risk that you're pointing out. My question here is, within the accountability and efficient spending of resources, what should be the guidelines with regard to simplified procedures? So, because we don't have harmonization, I think there should be more harmonization in order for the EPPO to work more effectively regarding simplified proceedings and the general European landscape. There should be more harmonization on admissibility of cross-border evidence, and there should be also more harmonization regarding the statute of limitations. Why I'm saying this? I'm saying this because the regulation says that there should be the college shall issue guidelines regarding when and how to apply simplified procedures, so plea agreements and other type of negotiated justice forms. In some countries, there are no negotiated justice forms. It's like in Sweden, and so that might be also an element, a factor to be taken into account when reallocating a case or trying to identify where to lead the investigation. Yes, Article 26.4 says the investigation shall be led and handled where the focus of criminality is, but there might be other issues taken into account, and changing that, as you all know, that allocation, a territorial allocation of the investigation when several countries have jurisdiction of those crimes. So residence, the elements that are mentioned in the regulations are residence, nationality, and where the main damages has occurred. My question is, these changes of allocation of cases, territorial allocation of cases, have to be taken into account by the principle of public interest. But public interest in accordance with the criteria of reallocation, this is nationality, residence, and where the main damages have occurred. I think there might be a contradiction, because public interest might be justifying the reallocation of the case to the jurisdiction, to the territory where the statute of limitation is longer, there is negotiated justice more efficient or more possible, or allows for this case to institute simplified procedures, or where the admissibility of evidence has lower standards and lower thresholds. So I'm not sure if the public interest can be interpreted like this, but I think there might be guidelines to be issued. And this is a question I put to you because you are at the trenches and the front row dealing with these issues. So how are those guidelines to be drafted, applied, and if this in particular public interest might be extended to other issues different from 26.4. And finally, what happens with them when you were talking about the conditions of employment and such legislative, so to say, legislative power by the college, that there might be the risk to extend the legislative power and interfere in, so to say, the balances of power and counter checks of our democracies. I don't see that. I don't see that risk immediate, but theoretically and in abstract, we have to think about it, of course. But do you think really it's more Dutch perspective, because the PPs are very much linked to the Ministry of Justice and are accountable to them? Because if I see here the management powers of the public prosecutors in the member states of the European Union, it's in fact Netherlands, one who is very much directed by the Ministry of Justice, but not all of them. No, so that would be my questions. Sorry for taking too much time, as always. Thank you.
Well, as much as I agree that we could and should have a unified EU legislation on simplified procedure and admissibility of cross-border evidence or statute limitation. These points will not influence the decision of the EPPO in any way. We will never, ever consider where it is more convenient to allocate a case because there is simplified procedure or evidence is admissible more easily or statute limitations are longer. This is really out of the question. We don't even start thinking about that. I would like that. I would like to have a criminal procedure code. I mean, like one of the things that when we started talking to the Defense Lawyers Association at a European level, and they were yelling for having a European criminal procedure code because they are aware, and as we are aware, that these discrepancies might create a negative effect and also a perception of choices based on this. But there is really nothing we can do. I mean, Article 40 about simplified procedure of the regulation starts with a if. If in a member state there is a simplified procedure, right? It means that it's not like that in all the member states. Yesterday, I don't remember who said it yesterday. In Italy, you can actually kind of enter a plea agreement for almost anything. And in France, it's almost impossible, right? And that makes a lot of difference. But the statute limitation, we know that in Italy, it's a big issue, right? Whereas in other member states, there's no way. I mean, it's like this is really irrelevant. So we are very, very, very aware of these differences, right? And that is not a point that we will never ever take in consideration when reallocating a case to another member state or making a decision to enter a plea agreement or whatever. The idea behind that, I mean, so I can say that so far we have not reallocated any case. Okay. This is actually, I have to say that we are far from that. I mean, personally, I don't see cases that have a potential for reallocation at the moment, but it will happen in the future. Yeah, that's without doubt. But this is what we take in consideration. And guidelines about simplified procedure, maybe Ingrid might want to say something about that, but about criteria for allocating the case to a member state or another, we might adopt them in the future if we see that operationally this becomes an issue. If we have no real issue with that, we will not adopt guidelines. But if we do have, we will adopt guidelines to supplement the regulation. Of course, we cannot go against the criteria of the regulation, but we can supplement. And we have the exceptional job that Eurojust did throughout all these years about that.
Thanks. Just to add a couple of words concerning simplified procedures. In fact, the college has adopted guidelines on simplified procedures, which hopefully are on our website. And actually, I was part of the team preparing the guidelines. And I must say, obviously, member states' legislation, and in fact, we have to apply national law in that respect. Which, as Danilo has said, is absolutely crystal clear from Article 40. Member states' legislation in that respect varies tremendously. Whether there will ever be an approximation or even harmonization of simplified procedures in the member states, that's a question for the EU legislature, a question of political will. But I could expect that this would also be, from a legal technical point of view, incredibly tricky. And I remember, I don't know whether Professor Ligeti is still here somewhere in the room, but I remember the attempts to create the model rules, which should have been a basis for something like a joint criminal procedure code for the EPPO, which obviously there was a lacking political will, shall we call it like that, to go for something like that. But then I think it also turned out to be incredibly difficult to really execute it, carry it out from a legal technical point of view, because actually if you adjust a little bit one provision concerning the investigation, you have to make sure that the result at the end of the proceedings will be the same. Would that be a ground to challenge the decision if there is infringement of that provision, for instance? All that is very, very difficult. Now, concerning the simplified procedures in the member states, actually, we learned that in some states, simplified procedures can only be applied to minor crimes, such as in my country. In other countries, actually, the simplified procedures are there, particularly for the major crimes. Then we have learned that in some countries, as in my country, you first have to terminate the investigation and establish what has happened, establish the facts, and then you apply a simplified procedure, whereas in other member states, actually, you apply the simplified procedure in order to not have to complete the lengthy investigation and really establish in detail what has happened. In some member states, you can apply it to companies. In others, you can't. So we really have a variety. In some member states, it's the prosecutor's office applying the simplified procedure. In other states, the prosecutor can just make a proposal to the court, and it's the court doing it, or it depends on the stage of the proceedings. So really, we have a lot of variety there. Full stop.
Let me pick up on one or two points that you mentioned. As to Article 40, the reality is that this is a compromise achieved under our presidency, precisely because some member states do not accept the concept of a transaction, as it is called in Belgium, the Netherlands, Austria, and find it barbaric, basically, from a legal point of view. They cannot envisage a situation where such a deal would be struck without a judge being involved. To the more pragmatic types, such as us, it's a very efficient way to end a potentially very long criminal procedure. We've had cases of transactions involving 700 million in relation to big banks. Now, I'm not saying that this is ideal, and in fact, the Parliament has asked for better rules on this because it got a bit out of hand in practice. But the principle as such is still accepted widely. So this Article 40 simply reflects the differences between the member states. Those that have such a kind of procedure will allow the EPPO to take advantage of it, and those that do not. It's basically as simple as that. It was just a very pragmatic solution to a discussion that had been ongoing for a very long time that we wanted to solve. What else? Yes, I'm not sure what graph you were showing me, which makes it difficult to react. So in very general terms, I will say that under the Dutch legislation, there is a possibility for the minister to give instructions to the prosecution service. The reality is that he never does. Even so, looking at a court case in Germany where there was a similar system, we have adapted our law on the surrender in line with their jurisprudence so that European arrest warrants will now be issued by a judge rather than the prosecutor. And there is a discussion based on a report that I've just received about the status of the prosecution service in light of such jurisprudence in general. So there will be a very interesting debate, because just suppose that we would take that theoretical possibility from the minister away out of the legislation. there would still be many links, financial ones, administrative ones. There would be the political responsibility, unless, based on the report that we are now studying, the conclusion would be that the Board of Prosecutors General would be directly responsible to Parliament, for instance, which is a possibility that some member states have. The Prosecutor General goes to Parliament if something goes wrong. Other member states have a system where the prosecution service directly negotiates with the Ministry of Finance to ensure the budget. All these modalities are foreseeable. So is it a typically Dutch point, is concerned about the impact of college decision? No. Various member states have reacted in different ways. Some have a tradition of adapting legislation. We have found a more practical solution, be it a bit contre cœur. But my point is that the impact of the decision is that the EDPs at the national level have become financially dependent on national authorities. And that, in my view, raises questions as to their independence. It could anyway. So that was basically the point I was trying to make.
Very briefly, I don't have much to add on the question of the simplified procedures. As Nicolas rightly recalled, during the negotiations in the Council, there were very long discussions, and which hit the obstacle represented in substance by the different approach in relation to what effect simplified procedure has in terms of assessing the historical fact and establishing a measure of criminal liability of the person that accesses it. At present, there was no possibility to get out of this impasse, and the article on simplified prosecution procedure is one of the most useless articles in the whole regulation, may I say, because it basically says do as you wish. It's a bit a reflection of the hands-off approach that the regulation has in relation to the decision on the res judicanda. So anything that happens in relation to courts is left to the courts. The regulation doesn't enter into it almost at all. To be fair, the initial Commission proposal wasn't exactly of high ambitions in this respect, so we'll see what happens in the future in practice. Just one observation in respect to your idea of harmonizing the rules for cross-border evidence, to recall to myself in Article 82, the only ground which has never been not only not exploited, but never even proposed to be exploited in terms of approximation of criminal law, is the one on cross-border evidence. So it's clear that in this respect, the European Union has still vastly unexplored territories that only wait for courageous explorers to go explore eventually at some point. But who knows, maybe the EPPO, with its intrinsic cross-border nature, can be a groundbreaker from this respect and show in practice what are the obstacles that indeed will have to be addressed at some point.
So thank you very much. I will now open the floor. Just one last reaction. Of course, I'm very much aware on the discussion and negotiations on Article 40 on the regulation, and that the terms of transactions and agreements were deleted from it and substituted by simplified proceedings. My point is that since it's the public prosecutors who promote and who take active action towards simplify plea agreements or other negotiated solutions. And despite that there might be some European Union countries that are still against the Council of Europe recommendation of 89, it's very clear. And those in general, it's recommended to apply more efficient, simplified proceedings and move towards discretionary prosecution. So since 89, and I would say it's exceptional in the cases that European Union countries have not introduced any kind of plea agreement or a speedy track disposition of the cases. And this is my precise point. You say, the regulation says, do as you wish. And do as you wish means that the delegated European public prosecutors should do as they wish, but they wish. What is that they wish should be kind of directed by the guidelines on the EPPO, because otherwise the different delegated prosecutors will be kind of shifting towards or not or blocking discretionary solutions or negotiated justice. That was my question. And precisely because I know that the landscape on solutions is so diverse. And thank you for addressing the 82 non-developed article of the treaty. And the courageous explorer is going to be me, because I'm leading a European Union project on admissibility of cross-border evidence and the possibility of drafting some European Union rules beyond what the model rules were. So I only count on you to help and provide your input, because that might make your life easier, I think. I don't know. But anyhow, the audience, please, questions and answers. We are willing to hear them. Is the micro somewhere to already clean and... Please, Hans-Holger.
Thank you very much to all of you for the insights to how the EPPO works in practice. I have 3 questions, 2 of them simple ones, but maybe not so simple to answer, and a third one that is a bit more complicated. The first simple question builds on something that Ingrid spoke about, that is the reports to the EPPO and the initiating of investigation. My question is, to what extent does the EPPO receive reports, I mean, not on evocation cases, but on new cases, receive reports at the central office, and to what extent at the national, the EDPs? Do you have a rough percentage? And connected with that, to what extent have you been receiving reports from EU institutions or bodies, for example, from Olaf? Presumably, Olaf has many cases in the files which could potentially be relevant for the EPPO. Can you say something about that? Second question, Article 31. You all know that this was heavily debated and a lot of speculation whether it will work in practice. Can you say something there yet already? Experience with the complicated system of Article 31 of who is in charge of judicial authorization and the concept of a single authorization. The third question, a bit more complicated. You spoke about Article 40. My question refers to Article 39. You know that the recital says that the catalog of dismissal grounds in Article 39 is a final list of dismissal grounds. And the issue has come up in the past whether and to what extent national provisions on dismissal can also still be applied by the EPPO. My question is whether the college has an idea about that, whether any issue have come up already. For example, questions of a temporal dismissal or suspension of investigations. If you are investigating Mr. X and Mr. X, however, is in Russia and Russia does not surrender the person to the EPPO, what do you do? Do you then finally dismiss the case, or do you suspend the investigation? And who takes that decision? Is that the role of the chamber to do, or does the EDP simply decide on that? Or a different scenario where you're investigating Mr. X because he has allegedly been committing 5 cases of smuggling. 5 separate cases of smuggling. And 4 of them are perfectly clear. You can go to court any day. And the 5th one, however, is more complicated to prove. It will not make a difference in the end because the person will get 5 years imprisonment anyhow. But do you then have to continue investigations for case number 5 until whenever you find sufficient proof, or can you partially dismiss the case against Mr. X and only bring the 4 cases to the court? And again, the question, who decides on that? Is that the EDP, or is there a role for the chambers? Thank you.
I was looking for the statistics, but I'm not really finding that one. But I can say that we receive a fair amount of information from private parties that and then in that case we have a very, very, very small percentage of cases that we effectively initiate based on the claims from the private parties, less than 3%. Then we have a large amount of information and criminal reports that we receive from the national authorities. I would say they make 70-75%, something like that. I don't know, Ingrid, if you have the statistics exactly there, but yeah. Yeah. Just well, just to be precise. Yeah. Yeah, by far, it is. Yeah, well, we have like around 50% of the criminal report received from the national authorities, around 40% from private parties, 10% from basically Olaf, and to a very minor extent, the European Investment Bank. But then when we go to the cases that we actually initiate, we have around 85-90% from the national authorities. That is the main source when it comes to quantity of our job, by far. I mean, like I could say that even without looking at the statistics that confirm this, but it's our everyday experience as supervising EP and in the permanent chambers. That's without a doubt. Well, Article 31, I was supposed to talk about that and there was no time, but I might want to say something about this. Well, I mean, like the real added value of Article 31 here of cross-border investigation is the fact that differently from whatever happened up to the 1st of June 2021, we take action as a single office. That's the big revolution. That's really different from any Eurojust coordination meeting, any European investigation order, any joint investigation team. We just sit together around the table, coordinate the ADPs, take action together. So that's easy. If only the prosecutor is involved, it's very easy, and we do it very quickly. We just understand the case, we talk to one another, and the assisting EDPs just take action under the coordination of the central office. But then the big deal is when the judges are involved. Then the scenario changes totally. That really changes, because we are facing difficulties, because the way Article 31 is drafted is creating some different interpretations that we will have to assess. We created already a steering working group to see whether we can issue guidelines or let's say, have a common understanding about that. Basically, the big news is you are not going to use the traditional tool of mutual legal assistance, even within the EU. You are not going to use the mutual recognition tools, right? So, and you're going to have just one judicial authorization. That's the principle. Yeah, but real life is not like that. So, it's if I have a case in Italy where I have a freezing order from the Italian judge, and then I find that there are funds in France or in Austria or in Germany, well, no, I need also the authorization from the German judge and the French judge. And what does the French judge want? Do they want the certificate that the regulation, the mutual recognition? Well, but we are not supposed to use it. So what are you going to give the judge? Nothing? No, he wants something. So at least the freezing order issued by the Italian judge. But then I have to translate it. So the certificate was quicker. So how are we going to do that? So you see, there's a lot of very complicated issues, but the principle of the single judicial authorization does not work. That's really impossible to use, because in order to take action, whenever it's a freezing, it's an arrest, it is obtaining telephone data, it is any kind of even invasive investigative action requires the authorization of a judge. Not to talk about interceptions, things like that. We always need the authorization of two judges, almost always. If judges are not involved, as I said, well, easy. Just wanted to say something about dismissal and and plea agreement, and let's say alternative Article 40. Well, these are decisions of the permanent chamber, and it's also what you said, Lorena. It's not an erratic decision of 140 different ADPs. It is a permanent chamber. It is in Article 40. The permanent chamber makes decision on applying plea agreement. So there is a centralized approach. There are guidelines, and the 15 permanent chambers really take all the horizontal issues to the college. We do it every week, actually. It's very tiring, but we have to do it because we need to have consistency. We need to be coherent throughout the 22 member states. So that's something that we have to do beforehand in order for the ADPs to have clear instructions, general instructions, not on the specific case, general instruction on how to behave. And that the same goes with dismissal or suspension, because of course we are going to apply the national legislation, which is different in different member states. But if we have to take a decision on dismissal, it's again, this is Article 10. This is one of the essential tasks of the permanent chamber. So that will be also centralized. We haven't encountered yet problems related to surrender or European arrest warrant or things like that. It's too early. We will see. But anyway, there will be a centralized approach. You can be sure about it.
Yes, please. Just to add a couple of words. Indeed, what the permanent chambers are mainly doing at present is to decide on which cases we take, which cases we evoke, and which cases where we initiate proceedings. I mean, always on the basis of the provisions according to the regulation that when the EDP wants to evoke a case, she does it, and then the chamber start monitoring the investigation. And the same goes for initiation. So there the EPs go ahead. Only when the EDPs suggest not to evoke a case or not to initiate, that goes to the permanent chamber for decision making at this stage. These are mainly the decisions that the permanent chambers take at present. We also had already case referral decisions, though, and we had instructions already from the permanent chambers given to the EDPs on case referrals, instructions on initiation of proceedings, instructions on evocation of proceedings. But I would like to highlight the importance of what Danilo has said. Obviously, legal issues will pop up. The legal issues Hans-Holger has highlighted, they will pop up at a certain stage, and then we will have to bring these questions to the college, because actually there is no, at least for my country, that is something very alien. There is no competence for the chief prosecutor to give instructions on how the permanent chambers should decide. That is exclusively a role for the college to ensure coherence and consistency of the decision-making of the permanent chambers, and that obviously will have an effect on how the EDPs will take their decisions. So, and I think we will take the legal issues, the legal questions, as they pop up, and try to find solutions. If you ask me personally, as for Article 39, the grounds for dismissal, I would read the regulations such that they are exclusive, it's a closed list, and any additional grounds for dismissal enshrined in national law would not apply. But that is my own reading. And once we have the first cases where this question arises, we will discuss it, and by that time we will then hopefully have an EPPO opinion.
Thank you for your comments. We are very much looking forward to more questions. So please, there's one asking for the mic over there. Balas. I remind you just to, even if many of us already, since yesterday, we know each other, but present yourself, please.
Is it on? Is it? Yeah, okay. So my name is Balázs Garanvölgyi. I'm a prosecutor in Hungary, so a non-participating member state, but I'm here on a private capacity, so I'm not expressing any official views on that. But anyhow, in the coffee break, I had a phone call from one of the German EDPs because I'm working at a department which is designated in the cooperation agreement for operational cases. And they practically identified, based on a EIO linked case, a Hungarian case, which is linked to a German EDP case. So just to tell you that practically it's working, it's moving on, and it's really happening now. And as Ingrid also mentioned, we already had a case where we had 4 or 5 countries involved in a cooperation, and it was really smoothly handled, and everybody was really happy. I think I will frame the email of the German prosecutor thanking for the smooth and quick cooperation for future purposes. Anyhow, this is not what I wanted to ask. My question is that I have the impression that in an ideal world you would have to deal only with operational questions and legal questions in connection with your operational work. But since the setup is as it is, I think this is my opinion, but I would like to know more more about your opinion on this, your take on this, that you eventually can't avoid to develop a stance on policy matters, because eventually the EPPO will ask to express opinions on, for example, independence of the prosecutors, not only the EDPs, but in a more broader sense. And also you will have to develop, in my view, a stance on policy matters like abolishing the 4200 custom procedure, which should have been done decades ago. We all know, but when this opinion comes from the EPPO, that could make a difference at the European level. Also reversing the VAT system and abolish the use of cash and so on and so on. So if you really, so in my view, the EPPO could really impact the roots of the problems, not only handling the symptoms as the cases are usually. I don't know what your take is on this issue, but I would like to know. Thank you.
Who wants to address the question, the comment?
Now, I think the regulation is very clear now. The European Chief Prosecutor represents the EPPO towards third parties, towards the outside world. And the European Chief Prosecutor is in charge of the management and the functioning of the office. The college, and I would actually agree with you, Balázs, the college is in charge of strategic matters, general issues arising from individual cases, obviously ensuring coherence, consistency of decision making. And actually here I come with my Eurojust experience. The Commission has, and I think still does and will continue, to ask Eurojust for Eurojust experience and expertise when it comes to issues related to cross-border investigations, serious crime, mutual recognition, mutual legal assistance. And I take it that in the future, the Commission will also consult the EPPO on policy issues when the Commission wants to make a proposal for any legislative act. Plus, in addition, the EPPO will have to report annually to the stakeholders, and this will also be an opportunity for us to actively and proactively highlight issues where we think there's a shortcoming in the legislation, be it either on EU level or at national level implementing EU provisions. And indeed, that is something, there is a role for the college based on the experience with individual cases. But at present, we are not yet there, to be honest.
Just a few more words about this. We are very, very careful when it comes to expressing a policy to the outside world, right? It's a very sensitive issue, and we know what that means. And we have a lot to say about technical issues. Custom Procedure 42, we will have a technical opinion. We will be consulted. There's no doubt about that, right? But independence, well, we don't need to have an opinion on that. It's already there. And we are just standing by. This is like the basic principle of our work. So I know I'm coming to that. And are we going to say that this should be a value throughout all the prosecutorial service of the EU? Well, but there is a quite landmark judgment of the Court of European Human Rights. It's Cobegi against Romania, just accidentally, and that says it clearly, very clearly, straightforward. And one of the big implications of this is, we've been reminded of the mechanism of dismissal of the European Chief Prosecutor, which is in the regulation Article 1416. But there is a big problem with the status of the European Chief Prosecutor, the European prosecutors, and the European delegated prosecutors, because we are temporary agents. So we are like functionaries. The disciplinary procedure for functionaries and temporary agents cannot be applied to us. It's written in that judgment. So what can be applied to us? Only 14 and 16, but there is no procedure there. There is nothing. It's like the appointing authority. What is the appointing authority? The chief prosecutor is appointed by 3 different authorities. We are appointed by the Council, which is the most political and less democratic institution in the European Union. That's impossible. We don't have a disciplinary procedure. We don't have a disciplinary procedure. There's only this reference in Article 1416 about dismissal, but disciplinary, there's a lot before this dismissal. And the only clear thing is that the Court of Justice, but only for the dismissal. Anything else? There is nothing. So that's about our status. For sure, this independence of the judiciary and of the prosecution has consequences on this. And we already brought it to the attention of the Commission, for sure. But then, again, it's not our opinion. It's already jurisprudence. It's already in the regulation. We are not going to fight for this. We are a prosecution service. This is not our role. But I think this is already inside our DNA. Then, not implemented in a lot of member states, yes, it's a different story.
Thank you. You touched upon one of the main issues that needs to be addressed, I think, at the European level, which is if we want really to provide some autonomy to the public prosecution and functional independence, the disciplinary proceedings have to be regulated much more in line with what is the judicial independence disciplinary proceedings law. So following, as you mentioned, European Court of Human Rights, the Volkov case should be also here applicable to prosecutors, I think, because this is one of the main problems. And but I think I don't know if you're envisaged to provide some kind of code of ethics for the EPPO. So that's in.
Yes, we already have.
Okay, you already have it. So, and disciplinary proceedings, I don't know, and how far. More questions, please. Because I mean, this is a very lively discussion. I was thinking about how do you deal in practice? This is out of complete ignorance. So mixed cases, a case where you find out an EPPO case, for example, Germany, and you start investigation there. And it appears during the investigation that the main focus of criminality is a non-EPPO country, for example, Hungary. In such case, you try to go back to the mutual recognition cooperation systems and implement the EIO. Do you resort to Eurojust in order to find who will have jurisdiction, or do you just split the cases?
Well, that's an easy answer. It's a yes. We have to use the European investigation order where possible. With Ireland and Denmark, for example, we cannot. They don't have it. So there we have to go to the old MLA system, and where we have a working arrangement, like with Hungary, we use it. Where we don't, we use the tools that are available to us. Brussels 2000 or more problematic, much more problematic.
But you split the case, or you try to decide
no.
with Eurojust?
Eurojust is involved if needs be. Yes, absolutely. We have a working arrangement with Eurojust as well. So, yeah, split the case. Well, we have to see. We have to see how the case is. What is inside the case? This is theoretical, but anything is possible. Actually, yeah. But we have the tools to cooperate, certainly with the non-participating member states, certainly with third countries in the Council of Europe area, and with a few third countries, because European Union has already agreements with the UK, with the US, with Japan, and they apply to us. And then we've been notified as competent authority when it comes to United Nations Convention on Corruption and Organized Crime. So that we have some tools. Strasbourg 59 is the most problematic anyway.
As for the question of whether we would split the case, actually the question is, would there be jurisdiction in Hungary for the case? If so, I take it that I think Hungary has the principle of legality, mandatory prosecution. I think the Hungarian prosecutor's office would have to initiate an investigation, and then there would be obviously be parallel investigations, one conducted by the EPPO, one conducted by Hungary. And what comes to my mind immediately is this lovely instrument of having joint investigation teams, which is what you apply at present when you have public prosecutors' offices in different member states conducting parallel proceedings, which is a successful instrument and a very good practical possibility to coordinate. And and once you have set up the joint investigation team, you would not even need a European investigation order, but could easily coordinate measures, investigative measures conducted by both authorities, and the results, the evidence could be shared easily. If no joint investigation team is set up, then obviously it would be mutual recognition instruments.
Thank you. Any more questions?
Yes, Madam Chair. Can you hear me?
Yes, we can hear you. We don't see you.
Yeah, we can.
Sorry for being a party crasher. I'm Jan Ingeram from the Court
Now
of
we see you.
of the European Union, and thank you very much. I've been following with much interest from Luxembourg the discussions. Thank you for all the speakers. Also yesterday, very interesting. I'm going to be in the panel this afternoon, but I had two remarks, between a remark and a question. The first is about Nicolas' intervention about accountability and the house search going seriously wrong. It's true there's no minister which you can call then to discuss it, but I thought about Article 113 of the regulation, which talks about non-contractual liability. So action for damages. I think Olaf also knows that it should be taken very seriously, such actions. They can be quite quite effective. It's not just about getting money, the damages, but it's also about controlling what happened. And I think a house search going seriously wrong could be brought before the general court by an action for damages, which would allow a certain form of control and therefore accountability on what happened at that occasion. That's my first point. It's a remark or a question as you wish to see it. The second one is about disciplinary procedures. I think most of you know that on the 30th of September, so just a week and a day ago, the Court of Justice rendered in its plenary court a judgment in a case, Court of Auditors, against a former member of the Court of Auditors, which I don't have to mention here. And it's about 120 pages long, the judgment, and there you can very well see what serious misconduct is. So you don't need a definition of serious misconduct, I think, to know what it could be. And even if you have a definition, you will never have it in an exhaustive way. With regard to the procedure, and I'm talking here very personally, so to paraphrase Nicola, if you don't agree, don't call the President of the Court of Justice. But the procedure, it's true that the EDP, that you're all temporary agents, but on the other hand, you have the EPPO regulation, so which is a lex specialis, which lex specialis derivat legi generalis, so it's not just the staff regulations or which become applicable to you. I would see it as EPPO regulation is a special law applicable. And to talk about the procedure, we have at the Court of Justice Article 6 of the statute, which allows judges also to be dismissed, a bit the same way as it is formulated in the EPPO regulation or as it is formulated for commissioners or for members of the Court of Auditors, but we don't have a procedure for that. I mean, we live without a procedure. Okay, we haven't had a case until now. But also in the case of the Court of Auditors, you don't really have a procedure. You have somewhere a decision-making procedure to bring it to the Court of Auditors. I mean, how should it be decided to bring it to the Court of Justice? But at the end of it, I might be seriously wrong, but I don't see the problem. As long as you say that the EPPO regulation is a lex specialis compared to the staff regulations, then for me the problem is solved, unless you see another problem. Thank you very much.
Thank you for your intervention, even if it's remotely. Anyone wants to address this? Otherwise, and yes, of course.
Thank you, Jan, for that observation. You are right, of course, in the sense that there is a mechanism for seeking to achieve some sort of compensation in the case of civil liability. But that was not actually the problem I was referring to. My case is about the, if you like, political consequence of something going seriously wrong, in the sense that somebody should take the responsibility and at least reflect on a way to avoid such a similar situation happening again. And the question is whether the EPPO would do that, and if in the longer run national parliaments would be satisfied with the fact that they cannot tell the minister or anyone else to sort out the mess. Thank you.
Thank you very much. I think we can conclude this very interesting and lively panel. I think we all have learned a lot, and I think you all have a difficult road ahead, but also a very inspiring, challenging, and passionating role. I thank you all for your patience here, for your contributions. And just one last comment with special thanks to this wonderful speakers, and a very very happy birthday for Nicholas, who has birthday tomorrow. But he undertook a lot of work already in advance, and if we are not having the chance to congratulate tomorrow, thank you, and happy birthday for tomorrow. So we resume later at I think, just for you to know, 2:30. Have a good lunch. Thank you.
Recording stopped. Recording in progress.
Bene, grazie. Possiamo riprendere.
Thank you. We can resume. With the afternoon session that is always more complicated. Our topic for this afternoon is particularly interesting. It's a new OLAF regulation, which has some positive aspects, and it does not change the preventive role that OLAF plays in the investigation role, which will have to be less pronounced in the case of EPPO, but it leaves many issues unresolved, and we cannot expect everything to be written down right away. The articles from 12A on, which have introduced innovations, include aspects that have not been so well regulated, such as the discipline concerning possible conflicts, not just because between OLAF and EPPO, but also between OLAF member states and the member states which recognize the EPPO, and particularly member states that don't. Investigative coordination in this sense, I think, is one of the biggest issues. I will not take any more time from the speakers, and I give the floor right away to Caterina Chinici, whom I've known for a long time, and well, we have been friends since the second half of the last century. So we give her the floor for her presentation, and then perhaps I will ask a few questions. Thank you. First of all, good evening to everyone. I wish to thank Mr. Biriteri for saying that we are old friends, and I'm particularly happy to be here today. I wish to thank the Basso Foundation for inviting me to participate in such an important conference. I'm sorry I could not participate in the other sessions, but I was in Strasbourg for the plenary European Parliament session, and I could only be here with you today with other distinguished speakers with whom we are going to share this task of sharing some thoughts about the your situation at the European level and the measures that have been adopted at the European level to protect the financial interest of the European Union. It is a notion that over the past few months, but I think over the past few years really, has played a very important role in political debate, also at the academic and case law level in the legal field. And it's always important to say that when we speak about the financial interests of the Union, we speak about the financial interests of the European citizens. So this leap forward that was made by European legislation in order to protect more effectively the financial interests of the European citizens and to fight against every form of offences and unlawful behaviours, misconduct in connection to the financial interests of the Union is something that should be shared and that should be also hailed and welcomed warmly, and that should also eliminate skepticism or bias that may be there in connection with the construction of a more compact European space. And I think that this aspect has already been highlighted during previous contributions. And in this field, within the field of a renewed commitment at the legislative level and at the European level in order to fight against all forms of offences connected to the financial interests of the Union, it is in this context that we should play the new OLAF regulation that was adopted in 2020, 2223. I was a shadow rapporteur in the drafting of this regulation 2020-2223,
and I was precisely a shadow rapporteur within the Committee on Budgetary Control. The new OLAF discipline should be placed within the framework of a new commitment by the European institutions to protect the financial interests of the Union. The first was the PIF directive that you already spoke about, I'm sure, and that was adopted during the previous legislature, and that our country integrated, transposed in its system in July 2020. The second important step, I think, was the regulation that established the EPPO. After establishing the European Public Prosecutor's Office, which, as we know, has a specific role to protect and fight against financial offenses, the criminal system aspect should have been further developed in order to protect the financial interests of the Union. And that is why it was decided to adopt this regulation. President Biriteri made some reference to possible issues that may emerge. It is possible that they do, but I have to reassure you in the sense that just as it was the case with the regulation on the EPPO, and as it normally happens in the case of those legislative acts or measures that have a significant impact, we're speaking about criminal offenses, which of course are of a more sensitive nature, where it's not always easy getting to a text that is shared. And I can testify to this because I worked on the new OLAF regulation, how complex the interparliamentary negotiation was, so within the various political groups and in holding different positions, as well as the positions of countries, and also the interinstitutional negotiations. So I think I can safely say that the text that eventually was produced, was drafted, is a text that is important, is valid, and highlights also the relevant role to be played by OLAF that carries out administrative inquiries, but also investigates on criminal offenses, and that must cooperate with the EPPO. So the new regulation on OLAF was aimed at developing OLAF's powers, strengthening its relations with member states, promoting cooperation between member states and OLAF, and then trying to regulate as precisely as possible the relationship, cooperation with the EPPO, establishing synergies and exchanges of information, strong cooperation, and a true complementarity between EPPO's activities and those carried out by OLAF in order to avoid overlaps or conflicts, which we shall see, because we know that the EPPO has only just started its activities, so we will then have to look at its functioning and cooperation between the two offices. From the standpoint of strengthening OLAF's activities, I think that a new element is represented by the fact that OLAF was given the tools that allow it to follow the money trail, an experience that we are very much conversant with. Follow the money, it's an English expression that we know well in this country, but I wish to state that I was, in a sense, the person who developed it, because this comes from the first difficult investigations that were carried out in Sicily by Rocco Chinnici, Paolo Borsellino, and Falcone. So follow the money, but the idea of following the money is something that comes from the Italian experience. If I may, Giovanni Falcone used to say, money has the heart of a rabbit and the legs of a hare. So it's easily scared by investigation and it runs away very quickly. So that is why it's so difficult to get hold of it. But the past has traced a path And another personal comment I would like to make, I am a member of the European Parliament because I committed to bringing the Italian experience that has cost so many sacrifices within the field of European legislation. So I am proud of results that were achieved at the European level at a cost on these topics. So getting back to the specific topic, one of the new elements to be highlighted within the field of strengthening the investigative powers of Olaf is precisely the fact that Olaf was given the necessary tools allowing it to follow the money trail, in the sense that the member states are obliged to communicate at the written request of the office, highlighting again the importance of establishing true cooperation relationships among the OLAF office and individual member states. So upon the written request of the office, they are required to communicate information available through automatic centralized mechanisms, which allowed the timely identification of any natural or legal person holding or controlling payment accounts, bank accounts, or safety deposit boxes. Where strictly necessary for the purposes of investigation, the competent national authorities are also required to provide the office with a record of transactions. Another important aspect is that of cooperation, not just with the EPPO, and I will quickly expand on it, but also with Eurojust and Europol, concluding administrative agreements with the two agencies, which may include the exchange of operational, strategic, or technical information, and possibly also, where appropriate, progress reports. And I think what is particularly significant is that in the working agreement that was recently concluded between Olaf and Europol, that agreement opens with the common awareness of the urgency of addressing the challenges posed by international organized crime, including terrorism and other forms of serious crime, and the links to illegal activities detrimental to the financial interests of the European Union. And in this sense, I wish to also add that among the first to raise the alert about possible infiltration of criminal organizations, for instance, in the management of European funding, which is going to come to our countries to help the member states come out of the financial crisis caused by the COVID pandemic. Well, one of the first was a national anti-mafia prosecutor. And again, with a view to strengthening the OLAF and its investigative powers to be able to carry out investigations in cooperation with the EPPO, we can say that there are also other aspects, and I move on quickly. There are also other aspects that are particularly important and that have been included in the new regulation. First of all, on-the-spot checks. On-the-spot checks and inspections. Another aspect is admissibility as evidence of the reports drawn up by the office, and also strengthening anti-fraud coordination services of the member states. As to on-the-spot checks, it should be highlighted that the new discipline seems to be more streamlined compared with the previous one. If the economic operator concerned by the investigation voluntarily submits to the on-the-spot check and inspection. And in this case, the reference to national legislation does not apply, but the legitimacy of the procedure followed by Olaf will be assessed solely on the basis of European law. Another important aspect is overcoming the so-called rule of equivalence, the principle according to which Olaf reports are admissible as evidence in judicial proceedings on the same basis and under the same conditions as the administrative reports drawn up by the national administrative inspectors, and are subject to the same rules of evaluation applicable to the administrative reports drawn up by the national administrative inspectors, also sharing their evidential value. Thanks to Article 11 of the new OLAF regulation, the rule of equivalence remains enforced only in the case of criminal proceedings, where the rules of admissibility and usability of evidence are notoriously more sensitive than in other proceedings. And this is going to be a problem, as Mr. Biriteri says. Again, with the view of making Olaf's action more effective. In this direction, there is new Article 12a, whereby each member state shall designate a service, anti-fraud coordination service, to facilitate effective cooperation and exchange of information with the office, including information of an operational nature. So we hope that this can provide an answer to those worries, preoccupations that were raised by Mr. Biriteri. So I quoted these articles to highlight how, in the new regulation, what was done was we tried to focus on and strengthen some essential aspects, such as the exchange of information, cooperation, coordination among the Union, EU bodies, and the competent national authorities. Of course, we then have to see what happens in practical terms and how this regulation is enforced. Another important aspect, and I try to quickly draw my conclusions, has to do with the relations between the OLAF, the Anti-Fraud Office, and the EPPO. Because in this case, too, it will be necessary to regulate appropriately, and this is what was done with the new regulation. So to regulate relations in a better way, to make cooperation between the two officers as effective as possible. And in fact, the regulation states that that relations that should be regulated through specific provisions. So the relations between the two officers shall be based on mutual cooperation, the exchange of information, complementarity, and avoidance of duplication. And I wish to also add also avoidance of potential conflicts. And Mr. Biriteri said so already, but the relevant articles are Articles 12 quarter to 12 octies that regulate the coordination of the work within the European Public Prosecutor's Office, starting with the reporting of criminal conduct to the EPPO by Olaf, if administrative inquiries identify unfounded allegations. Or so in this way, in the regulations, we try to identify areas of investigative competence that are contiguous but that are not overlapping, to the point that so much so that according to Article 12 Quinquis, the Director General of Olaf stops an open investigation and does not open a new investigation if EPPO is conducting an investigation on the same facts. But this relationship that we may define as being a joint investigation between the two institutions is well balanced by the possibility for Olaf under Article 12 Septis to carry out complementary investigations, complementary to those already opened by EPPO, if the Director General considers it appropriate in duly justified cases, and subject to the obligation to inform in writing the EPPO, which could oppose Olaf's initiative if it considered that this would jeopardize the continuation of its own investigations. Because without saying that when a complementary investigation is carried out, this must be carried out in close cooperation between the two authorities on the basis of a periodic exchange of information and evidence, so as to avoid unnecessary duplication and also a waste of the resources employed in the investigation activity. And I would also like to quickly quote Article 12 octis, that is the provision which is really the cornerstone of the relations between Olaf and the PPO. So the fact that the office Olaf must conclude working agreements with the EPPO in order to also establish practical processes for the exchange of information. And this exchange of information is very important for the purposes of the relations to be established between Olaf and the EPPO. This article was put into practice. I don't know if this was mentioned already by previous speakers. So this article was put into practice last July with the signing of a working agreement between the Director General of Olaf and the European Chief Prosecutor, Mrs. Tovesi, who last week illustrated the beginning of the EPPO's activities, highlighted the importance of its activities as an essential element in order to protect the financial interests of the Union, and also highlighted that it is necessary for the EPPO to be supported by all those who are involved in recovering European assets, particularly Olaf. I would like to conclude by saying something that I've already hinted at. I think that the introduction of the new regulation for anti-fraud, European anti-fraud office within the framework of a European legal system, which compared with the past is much more advanced in terms of fighting against financial offences detrimental to the Union. Well, this goes even beyond the simply strengthening the institutions that are responsible for protecting the financial interests of the Union. And I think that this regulation, the PIF directive, the PPO, and the new OLAF regulation really go in the direction of establishing a space of protection, justice, and freedom, as described by Article 3, Paragraph 2 of the European Union Treaty. So it's essential for judicial cooperation and investigative coordination must play an essential role in fighting against crime in an effective manner, fighting against organized crime, which, because it acts at the transnational level and because it makes use of the most sophisticated technologies, really represent great risk in terms of distorting markets and also in terms of financial offenses. And I wish to conclude by saying, by quoting Prosecutor Covesi, who before the Court of Justice recalled Italian magistrates such as Rocco Chinnici, Giovanni Falcone, and Paolo Borsellino, said that in order to protect the financial interests of the Europe, what we do is really protect the interests of citizens and therefore the values of democracy and the rule of law. And I think we all agree on that. And thank you very much for your attention.
Grazie a Caterina Chinnici.
I'd like to thank Caterina Chinnici. Because it's very stimulating and crucial aspect. I had sort of felt that I would ask you a question, which I'm no longer asking you. The question was, is there a danger that Olaf may be changed into a sort of a body that is at the service of EPPO? But you said it very clearly that what is at stake is a complementarity. It is synergy between the two bodies to sort of ensure the best possible results in detection of criminal associations which are sort of affecting the financial interest of Europe with sort of in a very professional form of transnational organized crime. Well, looking from the perspective of national judges, we would sort of hope that in the coming years we might eventually create a corpus of rules which are agreed by everyone, also in terms of criminal law and penal law. You have Lex Loci and Lex where the sort of the trial is organized before the French judge, the Italian judge, and the Portuguese judge. So with different procedures. That is the actual most crucial problem. The question of guarantees is okay. The problem of the form of trial is different from one different country in different countries. In terms of the criminal proceedings, it's extremely important that Europe becomes convinced that it's important to have a sort of set of rules which are homogeneous and in keeping with the regulations, with the same sort of rationale that led to the establishment of the National Directorate to combat mafia activities, with a view to sort of strengthen and enhance the fight, especially where investment, a very huge investment at stake, and the criminals groupings are very keen on trying to get hold of such resources. So I'll give the floor to Ernesto Bianchi. And I had sort of wanted to ask a couple of questions of him. Well, the operational framework of Olaf in light of the new regulation. Well, the new regulation has taken into account the need for sort of a loyal collaboration from 1 to 18 or 19. Well, this is something which is being pointed out throughout. And then there is the 12, Article 12, that says that there shouldn't be any overlap in investigations. Olaf should not overlap its investigation with those of EPPO. According to what Caterina Chinichi told us, well, we could interpret this that we have to avoid duplications. How can we achieve that? What sort of arrangements can we consider? I think that there are a number of governments that have in mind this possibility. So your position and your view is very important in terms of knowing which are the sort of techniques that can be used for this type of uh, investigations, which are complementary but not ancillary. Thank you very much, Chairman. Before shifting to English, because I have everything written in English, I'd like to thank once again Caterina Chinichi for the amount of work that she has carried out during the very difficult negotiation on the new OLAF regulation.
Happens with Olaf now that we have the EPPO in place. There's been quite a lot of discussions. Rivers of ink have already been poured, lots of words. I would like to start with that need to improve cooperation, of loyal cooperation, of building trust that I also introduced yesterday when I was explaining to you what Olaf does in terms of building knowledge, collecting knowledge, and using the knowledge that we have. And I'd like to begin from exactly where Mrs. Chinichi stopped, and that is that announcement of the adoption already of an agreement between Olaf and EPPO, which was a very important moment for us. We did not build that, and it was a deliberate intention of the chief prosecutor and of my director general. We did not build it on paper. It is built on practice. We started very early having coordination meetings at technical level between OLAF and EPPO, precisely to make sure that we would cover as much as we could foresee in that agreement, and by developing ways of working together that are based on dialogue, are based on sharing, are based on cooperation, are based on trust. And I have to say, I'm going to use an expression that my former colleague Luca De Matteis used this morning. You said, Luca, that the EPPO legal framework has resisted the impact of reality. The new legal framework of OLAF, as well as the cooperation, or the beginning of the cooperation between OLAF and EPPO. So we're very happy about that. Prosecutors and enforcement authorities in the member states were already used to working with OLAF. We're not new. We've been there 20 years. We have already an experience of really working side by side with judicial authorities in the member states. Now they're EDPS. So some of those links and connections were already there. Now we are developing more and more the connections. We communicated over to the EPPO roughly 150 cases that we were aware of. And for each one of them, there's been bilateral meetings to discuss between the investigators and the EDPS involved the content of the case, so that the information and that sharing of all we know is there from day one. And that has, of course, assisted, we think, also the colleagues, the EDPS, the EPPO, in making choices about what to take, when to take it. And of course, that's also the beginning of new collaborations on those cases and on other cases. We have already 11 cases of complementary investigations that are confirmed. So the structure of the complementary investigation works, and the added value is clearly visible for EPPO and for OLAF. Those are cases where there will be no duplication, because, as Mrs. Kinichi was saying, those cases are going to be based on the two teams working closely together. And of course, with the understanding that everything that we do in our administrative work in OLAF cannot interfere with a criminal investigation by the EPPO. That is already the case. We have 5 more complementary investigations that hopefully will be confirmed. And these are all cases in which we will be able to do the trick of allowing to, it's especially the case for customs cases now, but it will then go on and move on to expenditure as well, manage the trick of running after the money and making sure that the money is stopped from being spent, or recovered quickly when that can be, and at the same time, in a way, prepare the ground for prosecution by, if you want, doing the technical work that lies behind trying to track down what has happened with the money, with the financial fraud, and how fraud schemes were put in place by exploiting, as I told you yesterday, gaps in administrative law and in administrative practice, which is an increasing trend that we see. So the trick in making EPPO and OLAF work together is really in handling that complexity. We've heard yesterday afternoon, we've heard this morning as well, how complicated it is to make the EPPO regulation function. And of course, that level of hyper crystal clarity from a legal text is not possible. So at the end of the day, it is obvious that the practice makes the difference. What we do in OLAF, what we have been doing in OLAF, and what we will continue doing in OLAF, that's the value of the complementary. That's what we bring into this relationship with the EPPO, is our experience in managing to follow the money quickly. Administrative investigation and the access to bank accounts is a very good weapon, because we get to see bank account transactions much faster. We can do that across Europe, and we can reconstruct situations that are take a bit longer to do if you take the judicial route. And that is definitely something that we will continue doing. We can also recommend precautionary measures. So that we can see in certain situations that a project has been half funded, they still have to be funded. In that case, we can issue, and we do issue very quickly, recommendations for the line DGs not to pay, to take precautionary measures. And there's no better way to follow the money than preventing it from leaving your coffers in a way that's quite strong. The other thing that we have been doing and we will continue doing is trying to close those loopholes. We call that administrative recommendations. We know the inside working of the Brussels legal and administrative machinery quite well. It's a complicated world. We see that you really need to have that specialized knowledge that you only get by really working years and years and years in Brussels through the complexity of the systems that we have. Now, making administrative recommendations that make sense is not so easy as one would think. For example, this morning I heard the idea ventilated of, okay, well, there's Customs Procedure 42 is something that we don't like. I think it was you, Balázs. Let's scrap it. Well, the practical consequences of scrapping it is that Unilever will have to actually incur a lot more costs in importing stuff from outside Europe into Europe if you scrap it completely. So exactly, you're doing the balancing act. There is much value and much work that we need to do in looking at what we can recommend administratively that makes sense, that we need to discuss with our policy colleagues in DGs like DG Trade, DG Grow, because of course, we can't stop the economy because, if there is no trade, there is no fraud. That's not good enough. So it is that really complexity of handling this kind of situations. And of course, as Mrs. Chinichi one thing is for a Commission department to make a proposal to the Council and the Parliament, and another thing is to get that proposal adopted by the Council and the Parliament, not only in terms of time, but the content that comes out of it. So sometimes it's easier, and that's what we are trying to do, for example, on Customs Procedure 42, to look at improving the ways that it is implemented rather than scrapping the whole thing. I know you look skeptical, but there's ways of doing that, and we hope that we can. We also have another line of business that hasn't really come out in this context because we are really referring to the OLAF regulation. OLAF has another task that the Commission has given to it years ago, and that is the task of carrying out customs mutual assistance work. It sounds bureaucratic. It's called Regulation 515/97. That is what we are using more and more, actually, to do what yesterday I described as connecting the dots. It's building the bigger picture of fraud and fraudulent schemes. We've used it, for example, for our inquiries on COVID face masks quite a lot, where we actually saw that there was no attention paid whatsoever to linking the customs work with the work of the certificate check that what we put on our faces is okay to put on our faces. Huge gap there. It was a blind spot for everybody, and it was okay to have a blind spot in the first 3 months when face masks were impossible to find, but it is not okay now. So again, there's a lot of work that we need to build there. Another example that I can bring, for example, is on refrigerant gases, where we have, just by looking at loopholes in administrative law and administrative practice in the member states, we see now a huge traffic of counterfeit refrigerant gas. This is what we put in our cars, this is what we put in our homes to condition our houses and cars throughout the year. And the gases that are contained in there are actually toxic or can destroy the environment, the ozone layer. This is, again, connecting a lot of authorities, even inside the same member state, that did not used to interact with each other. And it's something that we do. It is time consuming, but more and more we find this aspect of polycriminality that we are working with Europol together to try to fight it, of organized crime investing in these new lines of business, in the face masks, in the refrigerant gases. Another example I can give you is in exporting plastic waste. It is illegal to export unsorted plastic waste from the European Union to a third country. It is not so difficult to circumvent it. I remember when I arrived in Olaf, I was shocked when my colleagues were explaining to me the practice of transshipment that was happening in Singapore, in Hong Kong, in all exotic places. Well, now we find transshipment of illegal plastic wastes inside the European Union as it moves from one member state to the other to find a good outlet to leave the European Union. Our yogurt boxes, vases that we rinse every morning end up in dumps in places like Malaysia, and children play around them. They're burned at night, polluting the environment there, but it's our environment, it's one planet. So these are all things that we're busy doing, and again, with great connect, with sad connections with organized crime every time is polycriminality for you. So it is really important that we have a system that allows to leave no stones unturned. We need to look at the administrative side just as well as we need to look at the criminal side of facts. Doing one thing only does not deliver the same result. And I think this is what the co-legislator, which is incarnated here today by you, Mrs. Chinichi, wanted from the new architecture. An architecture that can be confusing, that can be puzzling, can be difficult to see now, but we really have to make work. And we will, of course, do all we can to make sure that we do that. A word on expenditure, because I've only spoken about customs now, but there's expenditure too. I mentioned yesterday the challenges of Next Generation EU. We are talking about an enormous amount of money that needs to be spent in 3 years, roughly. Almost 800 billion euro. That money will be spent with an innovative scheme. That innovative scheme basically gives a lot of responsibility to control, audit bodies in the member states, often also at regional level. It's certainly the case in this country, but not only of this country. And there what we see again is this interest that has already been highlighted by Europol, but we see too already in the preparation of hundreds of fake companies in countries where it's not so difficult to register them. They're there already, ready to intervene. And it is really going to be very important that we manage again here the miracle of making sure that this information goes everywhere, from Tallinn to Lisbon. It is not easy, but that's what we have to do. And again, that it goes from Tallinn to Lisbon, that it goes from Europol to EPPO, to Olaf, to Eurojust, in this coordinated way of working together. That is something that is a challenge for all of us. Now, I wanted to look also at, I mentioned it yesterday very quickly, at another point that has been highlighted, I think, by you, President, and that's detection. Detection is, again, something that we can't do alone. The capacity of a national or a regional body to detect a bigger fraud scheme is a cross-border, a European or a world cross scheme is very low. You only see a tiny little section of it. We had a case that we presented in the Olaf report this year, a couple of years ago, when there was, in this country, there was a criminal investigation going on organized crime. So there were phone tappings, and in these phone tappings, all of a sudden, the Italian investigators here, something mentioned about buying agricultural machines from somewhere. And they listened into what these people were saying, but they didn't really quite get the bigger picture. So they came to us and they asked us to help them reconstruct what was going on, explain what was going on, and reconstruct what was going on. It took us about 4 or 5 months. And essentially it was, and that's why the Italian Guardia di Finanza couldn't really understand the bigger picture. These were agricultural machines bought from Germany at about 3-4 times the price. The payments were made to a company in Romania that would then move the money on to Bulgaria. So this is all deliberately done so that you involve more jurisdictions, and then following the money becomes a problem. The kickback payment was not just money returning back. No, they had invented, it did not exist. They had invented a system of sales from a Bulgarian company to a Romanian company that would then resell, but all different bank accounts, to a company in Italy of dry tomatoes that, of course, never passed any border and never passed any country. There was paper, there was money, but the dry tomatoes were not there. And it is really only by looking at all the administrative movements and looking at whether there were physical movements of the good that you can reconstruct in an administrative investigation what is going on. And the money involved in itself was not huge. I think it was 10 million euro. But again, it really gives you the picture of this organized crime now acting in smaller crimes, relatively smaller crimes of an administrative nature, because they're really hard to find. And that's our challenge, and that's where we have to beef up our cooperation at all levels, at European level, at national level. So we've been preparing, as I said, we put everything in place to do that. And the good news that I can bring to you again is that so far we haven't had any problem. We haven't seen any situation in which we were discussing with the colleagues in EPPO a potential conflict. We didn't detect that at all. So if we all know what we are doing in a system that works for the same aim in an environment of trust, I think that's not going to be really a problem. And of course, we have to continue working closely and making sure that we share information, that we trust each other as much as possible. And this applies also, President, to a system that includes in this cooperation network also the countries that are not part of the EPPO, because they are still part of our system. They are authorities that protect the internal market. They are the authorities that, at the end of the day, implement European policies. And we have learned it. If we don't have European policies that work as European policies, we fail. So I'm not going to go into more detail on this, but really to give you this message of optimism. So far, so good. And of course, we will continue doing all we can with our colleagues to work in this condition for the protection of the financial interest of the EU and for the protection of the citizens of Europe and the credibility of Europe itself. Thank you very much.
Grazie Ernesto Bianchi. Mi scuso per...
Thank you, Ernesto Bianchi. I apologize for not greeting all those who are following us remotely when we started this session, but I am very fond of live meetings, and sometimes I forget and do not do my job as I should. Thank you, Ernesto Bianchi, because if we needed proof that reality is complex, well, I think you gave ample proof of it, and also confirmed the central role played by farming, since from tractors you got to dry tomatoes. It's always fascinating in this sense what happens. But I think I can draw from your presentation a message of great optimism concerning the future effectiveness of investigations protecting the financial interests of Europe. And I see that as being rooted in history. Some 40 years ago, when we started understanding what Cosa Nostra was, the mafia, judges started speaking with each other. So the various judges, such as Rocco Chinnici, were investigating individual offenses. So in a sense, we were only seeing some part of an offenses separately. Then when we realized that we had to see that as a phenomenon, as something global, then we started really fighting against crime, a type of organized crime that has evolved, that has become European and international. Well, I think that being in contact with other experts has really stimulated me. And what I would like to share with you in this sense is the following. The presence of EDPs in Italian PPOs, there are many in Italy, small international ones, Rome, Palermo, Catania. Of course, some of them have no problem with the PPO, with Olaf, but there are some small PPOs that have never cooperated with Olaf, even though they could have. And now I hope that through a greater awareness of what the EPPO is, because we have it here in our own country, we can start a system marked by a greater cooperation, also in small investigations where you see that there are problems such as these structures that are going to be turned into dried tomatoes in the future, to then be placed in some can, and perhaps ending up in as canned tomatoes in some European high security regions. So with the hope of future effectiveness, and we know that Italy has an excellent investigative system because we were affected by organized crime and terrorism for a long time. We were the first in Europe to have been able to develop a system of to fight against this phenomena. So we can really act in synergy and help the smaller PPOs grow. Officers that perhaps in the past few years were not involved in this European investigative system that has now been put in place. I would like to tell Diana that there is an aspect, the fifth paragraph entails the obligation of stopping investigations when EPPO investigations are started. How can we recover this sort of step in the sense that so that we do not waste resources and we acquire data?
So I think I will touch upon this point towards the end of my presentation. So I'm not, if you allow me, I will not respond immediately. But before starting, I would like to join the other speakers to thank the organizers of Fondazione Basso for inviting all of us to this very, very interesting conference, which deals with interesting and important topics, I would say. And I would start by referring to the title of this conference, which is The New Anti-Fraud Institutional and Legislative Landscape. We've heard a lot until now about the PIF directive, about the EPPO regulation. So we know until now a bit more about how EPPO functions, the problems that they face in practice. So we discussed a lot about a new actor, a new, if you allow me to say this, a new kid in a room, okay? But this this afternoon session is dedicated to Olaf, which is, I would say, the old actor in this institutional landscape. An old actor with 22 years of experience, which we, as Ernesto said, we are trying to use now to support EPPO and to work together in this new framework, new landscape. And again, as Ernesto highlighted, Olaf continues to work as it used to work until now in those member states which do not participate in the EPPO. So our role is different now. It has changed a bit, but there is a lot which comes from the past. And precisely because of these changes, it was necessary to change also OLAF regulation. We heard a lot until now from the legislator point of view. It was very interesting for me to hear someone who participated, who was in the heart of the negotiations. We heard also the point of view from an operational point of view, from someone who is conducting an investigation. So my presentation today will be more from a legal point of view. I'll try to complement and not to repeat too much what was said until now. And I would say that I want to point out to two major things. Why was this regulation changed? It was changed because it was necessary to allow Olaf to work better and to work with the EPPO. To work better, we heard already. Olaf needed to have more stronger investigative tools, but it was also necessary to ensure more coherence between the rules, more coordination with the member states. It was necessary to have more clarity on some specific rules which were already in the regulation, but when applied in practice, the reality showed that they were not so clear. So in the end, there was a set of rule which needed to be changed to reinforce Olaf. But on the other side, Olaf was given, I would say, more powers, more tools, stronger tools. But it was also necessary to set a better balance, to improve the checks and balances which were already in the regulation. And this is why I would say that a very important achievement of Olaf regulation was the fact that whereas the the changes that were made did not affect the procedural guarantees which were already in the regulation, the protection of the procedural guarantees has been reinforced, I would say, significantly, in a very important manner, by two novelties. On one side, there was a function of controller of procedural guarantees which was created, and on the other side, of course, to help the controller function, there was a new procedure which was introduced in the regulation, and this is the complaints mechanism. And I think with this, I already gave you a flavor of my next points. As I said, I will try not to repeat too much what was already said. I will just point out in a few words the most significant changes and why they were important for us. So when it comes first to the investigative tools which were improved for Olaf, Mrs. Kinich already mentioned the fact that there was this new provision which was about the obligation for national authorities to give access to information on bank accounts and transactions. I will not insist too much on this. Another very important tool, which is quite new, we'll see how it will work in practice, is the provision which allows Olaf to inspect privately owned devices which are used for work purposes. This is something which is we feel already as lawyers, it's something which will be quite challenging to apply in practice. The principle is the same in external and internal investigations. Olaf will be able to inspect private devices, which are used for work purposes. Of course, this is, I would say, an intrusive means of investigation, which means that it was also necessary to introduce some checks and balances, to introduce some safeguards. And these are a bit different depending on the type of investigation. So what is common is two conditions. Olaf can inspect such devices if it has reasonable grounds to suspect that the content of these devices are relevant for the investigation. And if, of course, the private devices are used for work purposes, it goes, I would say, even it it's natural that this is accompanied by principles of necessity and proportionality. What is different in the two types of investigations is the fact that in external investigations, Olaf's powers are have to be subject to the same conditions as the conditions that apply to national control authorities, whereas in internal investigations, Olaf's powers may be subject to specific conditions which are to be set up by the EU institutions, bodies, agencies, etc. So we'll see how in practice this will work, because these are ongoing discussions. It's not something which has been already implemented. It will come. I was mentioning also the fact that it was necessary to ensure more coherence between the existing rules, better coordination, and without giving too many examples. I would only mention the fact that, for instance, at some point there was a better alignment of provisions between concerning internal and external investigations, but also between the provisions concerning what happens when Olaf does not open an investigation, even when it has suspicion that has been fraud, corruption, or illegal activities affecting the financial interests. The new provisions ensure that Olaf transmits the relevant information to competent authorities, and also that Olaf takes into consideration any possible interference with the ongoing investigations by the EPPO. Mrs. Kinic already mentioned the fact that there is now more clarity concerning the law applicable in the course of on-the-spot checks and inspections. So I would not insist on this point, but for us it is very important, because this is precisely the case when we saw that the rules were the rules in the regulation, in on the spot check regulation plus Olaf regulation, but in practice it was different. So based on Olaf's practice and the case law, I will mention here the judgment Sigma Orionis versus Commission. So it was very good for us that the legislator clarified these provisions. And because I mentioned the coherence, which was one of the, I would say, the achievements of the changes in the regulation, I think it's important to mention that in the context of on-the-spot checks and inspections, there is this obligation of the member state authorities to assist Olaf. And in one of the recitals of the Olaf regulation, it is very important that it is said that the Commission can take or should take the member states' failure to comply with the duty to cooperate with Olaf into account in considering whether to recover the amounts concerned through the application of financial corrections. And why is this important? Because also in December 2020, so last year, when Olaf regulation was changed, there was another very important regulation which was adopted, and this is the so-called conditionality regulation, which allows allows the Commission to act when it is established that breaches of the principles of the rule of law affect or seriously affect risk affecting the sound financial management of the union budget. And one of the cases, or situations which are mentioned in the conditionality regulation when it is possible to act, is lack of effective or untimely cooperation with Olaf and with the EPPO. So it is important to have in view the whole picture. One last point that I would mention, just as a title, but without entering into details, is the fact that there are new rules which are, I would say, are about more effective and more consistent use of Olaf's reports. And Mrs. Kinic already mentioned the rules on the admissibility of Olaf's reports as evidence in criminal proceedings. But what is new for us, and it is also very good, is the fact that these reports are admissible evidence also at EU level. Meaning, for instance, in administrative and judicial proceedings before the Court of Justice, or proceedings of the EU institutions and bodies. As I was saying before, more powers means also more protection. on the other side, if we see the other side of the balance. So the two major innovations that are in the regulation, as I said, are the establishment of the controller of procedural guarantees and the setting up of a new complaints mechanism. A few words about the controller. Who is that person? What does he do? What is the scope of the action, and what is the impact of the action of the controller on Olaf? So again, this is very theoretical because it has not happened yet in practice. But just a few words about it. So the controller is an internal function of control of Olaf's compliance with procedural guarantees. At the same time, the controller is a person who will be appointed by the Commission. The procedure is very well explained in the regulation. You will be happy to know maybe that the procedure is ongoing, so we would expect that the controller will be appointed soon. The role of the controller will be to monitor Olaf's compliance with procedural guarantees, fundamental rights, and the rules applicable to investigation. So there is a whole set of rules that the controller will be able to verify the compliance with, and how he or she will do this by handling complaints against Olaf. But the scope of these complaints would be quite limited, yes and no, because there will be complaints submitted by persons concerned in Olaf investigations. At the same time, we can expect that now that there are specific provisions in the regulation, we can expect that there are a certain number of complaints. We will see. But also, this means that complaints submitted by other persons, like witnesses or informants, will not be within the scope or mandate of the controller. These complaints will be or will continue to be dealt with by Olaf. As I said, there is also a new complaints mechanism. Complaints mechanism means, in fact, the procedure which will be applicable to these complaints. But again, I will not give too many details because the procedure is quite well developed in the regulation. But in a nutshell, what the controller will be able to do if there is, let's hope not, but if there is an instance of non-compliance with procedural guarantees or rules applicable to investigations, the controller will be able to propose a solution to solve the complaint or to issue a recommendation. Of course, this will happen following an adversarial procedure. The controller will hear the person complaining, Olaf, and very important to say that Olaf will continue to conduct its investigation. A complaint will not have a suspensive effect on the conduct of the investigation. What is also important to know is that the controller may recommend, amongst others, we'll see the list of possible solutions that the controller can propose is not exhaustive in the regulation, but the most important are there. So the controller may recommend to Olaf to amend or repeal its recommendations or reports. This means, for instance, if an investigation is closed and there is a complaint shortly after, meaning at the latest 1 month after, and if there is a problem, and if the controller will recommend to the Director General to amend or repeal a recommendation or report, this will have serious consequences for us because we will probably need to reopen the investigation, to change some documents, to resend them to the follow-up authorities, etc. But we'll see again in practice how this will work. And of course, we are prepared for this, even if the controller has not arrived yet. But we have just modified our guidelines on investigation procedures, and we have introduced new rules for us to help us to guide us in how to deal with requests and recommendations made by the controller. Of course, just to mention as examples without entering into details, additional procedural safeguards have been also introduced in the revised Olaf regulation. Maybe one of the most important is the fact that when Olaf will carry out support measures for the EPPO, Olaf will have to comply with the procedural guarantees which are set out in Chapter 6 of the EPPO regulation. There are some additional procedural guarantees in the context on the spot checks and inspections, a new provision on access to the final reports drawn up by OLAF, which will change a bit our practice, because until now we were refusing access to the final report. Now, under specific conditions which are set out in the new Article 10.3b, we'll probably be obliged to give access to the final report, but really under very, very strict conditions, one of which will be, for instance, I will not mention them all, but one of which is to respect the confidentiality rights of informants and whistleblowers. And I wanted to mention whistleblowers because one of the new provisions of the regulation is also this reference to the protection of persons reporting serious breaches of law, and there is a specific mention or reference to the whistleblowing directive. It is very important because it's something new. And to go to the second part of my presentation, but again I'll pass very quickly, how the legislator has prepared OLAF to work together with the EPPO by introducing new provisions, which have been already mentioned here. These are the provisions in Article 12C until 12G of the OLAF regulation. So these are in fact mirroring provisions. They mirror similar provisions in the EPPO regulation, and they concern reporting criminal conduct to the EPPO, non-duplication of investigations, OLAF support to the EPPO, complementary investigations, and OLAF EPPO working arrangements. A few words about each of them. Reporting criminal conduct to the EPPO, we have already starting to do it. We do it via what we call EPPO crime report. So the content of the report is also indicated in the regulation. We are obliged to inform EPPO without delay. What happens if we inform during an OLAF investigation, supposing that we conduct an administrative investigation, and in the course of the administrative investigation we discover criminal elements, so we report to the EPPO, and we may discontinue our investigation because there is this principle of non-duplication of investigation. So if the EPPO will conduct a criminal investigation into the same facts, we will probably discontinue our investigation unless we conduct support measures or unless we conduct a complementary investigation. Speaking of the principle of non-duplication of investigations, and I hope to reply to your question, what does it mean? It means exactly what I said before. If there is an ongoing investigation and we discover criminal elements, we will stop unless the EPPO asks us to carry out support measures, or unless we can complement OLAF's EPPO investigation. If we discover this before opening an investigation, of course, we will not open it. How do we check this? We check this on the basis of indirect access to EPPO's case management system. It's a hit-no-hit system. Basically, if there is a match between our case and EPPO's case, we in the framework of coordination, consultation, dialogue, we will EPPO and OLAF will decide what will be the course of action. But of course, the information goes in both ways. EPPO also will inform OLAF when it decides not to conduct an investigation or to dismiss the case. It was also mentioned the fact that OLAF will support the EPPO or will carry out complementary investigations. So these are two different things. What does it mean? Support to the EPPO will mean to provide the EPPO with information, expertise, forensic analysis, operational support. It means also to coordinate the action of the national administrative activities or to carry out investigations, but strictly in support to the EPPO. Complementary investigations are something different. This is something which is, there will be independent investigations carried by OLAF within its mandate, but in close consultation with the EPPO. And there are these provisions in Article 12F saying that Olaf shall consult the EPPO, and the EPPO may object to the opening of a complementary investigation or may object to the performance of certain investigative acts. So you can see that there are rules very clear, I hope. I mean, in theory, they are clear. In practice, we'll see, which allow avoiding that we duplicate efforts and spend resources without justification. And I would say, this brings me to the end of my presentation. I would say that we are I hope, quite well prepared for this. The working arrangements have already been mentioned. They were signed in July, so we are already operating based on these working arrangements. We have modified also our guidelines on investigation procedures, and I'm happy to announce you that they have been adopted this week, and they will be entering into force as of next Monday, so it's something very new. And finally, we have Olaf has also been reorganized very recently, and one of the features of the new reorganization is the fact that we have a new unit which is dedicated to operation coordination with the EPPO. So at least on paper, we are prepared. Now, in practice, challenges, I'm sure that we will find they will happen day by day, but we just need, as Ernesto said, to cooperate, discuss, consult each other, and to work together. So, because this is all new for us, I would say that it is the start of a new journey to get together. We'll see how this will work in practice. And I think that the next if I can say like this, rendezvous is the next Commission evaluation of the implementation of Olaf regulations. So maybe in a few years' time, we'll speak again about how effective all these changes have been. Thank you very much for your attention.
Grazie Diana, spunti
Thanks, Diana. Very interesting inputs keep on flowing as much as the work in flow, in progress aspect of the praxis that emerges in order to solve the problems that arise. So this is complicated, but it's fascinating as we see how a new model of efficiency comes to light when I've seen in the course of time that when you had good minds taking care of all the organizational aspects, you have good results. We can then also convince the states that are more reluctant to somehow accept to transfer powers in terms of investigative powers. So
online. Benissimo.
Please, we're glad that you are online, so the floor is yours, and we welcome you remotely. Unfortunately, from the podium, we cannot.
Bene, adesso finalmente lo vediamo.
Okay, so we see you now, and we are very happy to give you the floor for your presentation, and I apologize for not having realized you were remotely connected.
And so many greetings from Luxembourg, ladies and gentlemen, dear co-panelists, dear colleagues. I would like to thank so my name is Jan Ingelram. I'm a director and legal advisor on administrative matters of the Court of Justice of the European Union. And I would like to share some personal reflections. The reflections are personal, not those of the institution, with you. And to start, I would like to thank the Fondazione Basso for having invited me, and also to have allowed me to do it online, which was not possible otherwise. And then to participate in this panel on the new legal framework resulting from Regulation 2020/2020-23, which I will call the 2020 regulation further in my expose. As its title indicates, the 2020 regulation has a twofold objective. It is first organizing cooperation between OLAF and the EPPO, and secondly, enhancing the effectiveness of OLAF's investigations. To go over briefly these two objectives, the first one, organizing cooperation between OLAF and the EPPO, there are many aspects to this cooperation already. For example, non-duplication of investigations was mentioned, but I would like to deal with one specific one, namely procedural guarantees. Considering the fact that the EPPO may request OLAF to conduct administrative investigations, that was already provided for in the EPPO regulation and is provided also for in the new amended OLAF regulation. The procedural guarantees applicable to OLAF and to the EPPO should in principle be equivalent when OLAF conducts investigations for the EPPO. It's clear that the EPPO cannot circumvent the procedural guarantees applicable to it by asking OLAF to conduct an investigation with different safeguards applicable. So the 2020 regulation indeed explicitly mentions that where OLAF conducts investigations for the EPPO and OLAF, acting in close cooperation, shall ensure that the applicable procedural safeguards of Chapter 6 of the EPPO regulation are observed. And this Chapter 6 now has two articles. It has Article 41 and Article 42. To say something about Article 41, it states that any suspect or accused person in criminal proceedings shall at a minimum have the procedural rights provided for in union law in criminal proceedings of the EPPO. And I quote some here, the right to information and access to the case materials, the right of access to a lawyer, the right to remain silent, and the right to be presumed innocent. These procedural rights also exist, with those which I've mentioned, in the context of OLAF investigations, so there's equivalency there. But there's one right which does not exist in the OLAF context. This is the right of access to the file. This has been constantly also decided in court cases. There's the right of access to the fundamental right of access to the file doesn't apply to OLAF investigations. But an equivalent right of access to the case materials, which is in fact an right of access to the file, exists in the context of the EPPO. Since the EPPO procedural safeguards will apply, the right of access to the case materials should also apply when OLAF conducts administrative investigations for the EPPO. So perhaps it will be interesting to see whether this will lead to a first exception to the absence of a right of access to the file in the context of OLAF investigations. It's more a question which I submit than an answer that I give, but it was a reflection which came up when I read this article on the application of EPPO safeguards to OLAF when it conducts investigations for the EPPO. The second one, Article 42, is on judicial review, and that's a very, very interesting and a very delicate article. On judicial review, it provides that as a general rule, national courts have jurisdiction to review procedural acts of the EPPO that are intended to produce legal effects vis-à-vis the other. So the national courts are in principle competent. And then Article 42 also defines some specific issues on which the EU courts have jurisdiction. If you allow me a small excursus here from the subject matter of OLAF, strictly speaking, I think also Luca Di Matteis this morning gave already a very interesting overview of all the possible and impossible legal questions which can arise in the context of the EPPO. I think that this Article 42 is also one, because it's an ad hoc solution, very clearly. And so how now, who will be competent when is not always clear. And there is one provision which intrigues me here in the EPPO regulation. It is Article 42, paragraph 2 under C, which gives the ECJ jurisdiction under Article 267, that's the preliminary ruling procedure, where a national court asks a question to the Court of Justice concerning the interpretation of Articles 22 and 25 of the EPPO regulation in relation to any conflict of competence between the EPPO and the competent national authorities. We discussed yesterday a lot about competence. Also, Lorenzo Salazar mentioned the issue. But I'm personally intrigued because the preliminary ruling procedure under 267 is clearly a procedure where a national court asks a question of interpretation or validity of European Union to the Court of Justice, where it needs this answer to adjudicate a case. So, and this is an instrument of cooperation between Court of Justice and national courts. So, unless something is escaping me, the mere question or a conflict of competence between a national court and the EPPO, I don't see how it can be just sent under 267 to the Court of Justice. But okay, the provision is there, so let's have ourselves surprised by, if ever the issue is there, how it will be solved. Now, to come back to my to Article 42 on judicial review, so EPPO, national courts are in principle competent, and now with Olaf. The situation is very different, or is different for Olaf, because Olaf is a part of the European Commission. Its acts, so reports and so on, are acts of an EU institution. And national courts do not have jurisdiction to declare acts of an EU institution invalid. Only EU courts can do so. That's constant case law. I'm not going into details here. It is true that national courts have jurisdiction to judge on the admissibility of Olaf reports as evidence in national procedures, but this is still something entirely different from reviewing the legality of that report under EU law, which is a matter for the EU courts only. And if the national court has a doubt on the validity of that report, it should send a question to the Court of Justice. This was also in the Tilak case already confirmed by the General Court. So there's a fundamental difference between the EPPO and Olaf as regards the courts having jurisdiction to review their acts. And this difference goes back to primary EU law. So for me personally, it's not immediately clear exactly how the provisions on judicial review applicable to the EPPO can apply or will apply or can apply to Olaf investigations conducted for the EPPO. It's an open question for me, but every question can find an answer in the future. But I think this is an important issue going back to primary EU law. And we have to see. So Olaf conducting administrative investigations for the EPPO will, I think, undoubtedly give rise to a series of interesting legal questions. Briefly on the second objective of the 2020 regulation, which is enhancing the effectiveness of Olaf's investigations. There were several changes and many have already been discussed by speakers before me. For me personally, there are four major changes or sets of changes which I deduced from the new regulation, 2020 regulation. The first is a change in relation to the applicable law to Olaf investigations. The second is strengthening some of Olaf investigative powers. 3 is also a change in the position of Olaf towards the Commission. I don't think this has been discussed yet. I'll come to it. And 4 is the establishment of the controller of procedural guarantees. First, the change in relation to the applicable laws. This has already been mentioned by Mrs. Kinichi. There are 2 elements there, and also by Mrs. Riochet. So the legal framework has been simplified, and I think this is very important. This is not only enhances the efficiency of Olaf, but it also gives legal certainty to all parties involved. So it's not just Olaf benefiting from this simplification of legal framework, it is all parties involved. So first, when on the spot checks and inspections and the economic operator does not oppose, then only EU law applies. As Ms. Riochet mentioned, this was already decided in the General Court's judgment of the 3rd of May 2018 in case Sigma Orionis versus Commission. So in fact, it was already the law under the 2013 regulation, but I mean, it's always better to put it clear in the regulation itself that that is the law. So question of legal certainty also. And then also duplication of applicable laws is no longer there when the report is used elsewhere than in criminal proceedings. Then the rules applicable to national administrative inspectors do no longer apply. So that's also, I think, an important clarification. That is new compared to the other one, which is in fact called a consolidation of case law. A second change or set of changes is strengthening or at least clarification of Olaf's investigative powers. I think should be mentioned here is the duty on economic operators to cooperate with Olaf and to provide information, which is now explicitly in the regulation, which already existed for in the context of internal investigations for EU staff, but it's new, at least explicitly, in the context of external investigations for economic operators, and as far as I can read. However, I think it's always important to remind that the practical effect of such a duty of information is limited to the extent that the right not to incriminate oneself comes looking behind the corner, and that it must always be balanced against that right. So it is always more. I have always thought it is more or less relative duty. Can be. I mean, theoretically is important, but in practice, it can be relative. And then the privately owned devices, also mentioned by Mr. Rio. I started by saying the new or new power or clarification. I think it's interesting to see that Olaf already considered that it could inspect privately owned devices, because also it had adopted internal rules on the way in which an inspection of privately owned devices could be done. That is the 2016 internal rules on digital forensic operations, already mentions in Article 5 the way in which Olaf could inspect. So it's not a real new power. What is new is that it's now in the Olaf regulation explicitly mentioned. It's interesting to see also that it was not in the Commission's proposal, so it is somewhere in the legislative process. It has been introduced. It's also interesting to see that for internal investigations, each institution has to define the conditions for such an examination of privately owned devices. And I don't think I tell a secret that currently all institutions are struggling with such a decision. It's, on the other hand, an important, I think, important for the efficiency of the investigations of Olaf, because let us not forget that it allows Olaf to inspect privately owned devices, for example, in a Bring Your Own Device program, BYOD. And certainly with also COVID and so on, push mails are often on the private smartphones of people working for a company or for the institutions. The Court of Justice also has the Bring Your Own Device program for push mails this allows, this gives certainty on the possibility for Olaf to investigate these privately owned devices, which are, of course, as already mentioned also by Ms. Riochet, it's quite delicate because you're very close, you're interfering with the fundamental right to respect for private and family life enshrined in Article 7 of the Charter. What I would like to add also here is that, talking about the judgment I already mentioned in my intervention this morning of the 30th of September 2021, so 9 days ago, a Court of Auditors against a former member of the Court of Auditors on serious misconduct. I read with much interest the paragraphs 162 to 166, where the court clearly states that the fact that information is of a private nature is not as such an obstacle to Olaf's investigative powers. So it's not because something has private or even it's a private device that for that reason it's automatically in violation of the fundamental right to respect for private and family life, and that therefore Olaf would perhaps not have competence power investigation. So that is not the case. This is explicitly, you can read explicitly or deduce it from paragraphs 162 to 166 of the judgment of the 30th of September. The bank account information has already been mentioned also. So I've just, it's not new. I mean, if you read the preamble of the regulation, it's clear that Olaf already had information in a number of member states, but it's important now that it has been throughout the Union, that there's a common approach throughout the European Union. And I think it's one of the most visible changes, most visible and striking changes to the 2020 regulation. If one talks about bank account information, it's always, everybody's looking up automatically. The third change relates to the position of Olaf towards the European Commission, to which it structurally belongs. Olaf has always been independent from the European Commission in relation to its investigation activities, that already since 1999. But the 2020 regulation has extended this to coordination activities, which of course also this independency, extended independency, undoubtedly strengthens Olaf's position towards the European Commission and towards the member states. But I think personally it raises a question of an institutional nature. Because Article 325, paragraph 3 of the Treaty on the Functioning of the European Union, there is a reference to the coordination task. It imposes on the member states the obligation to coordinate their anti-fraud activities together with the Commission. The Commission is explicitly mentioned in the treaty. So an interesting question is whether this treaty article allows the European Commission to pass on this coordination task conferred upon it directly by the treaty to Olaf, which is an independent office to which the Commission cannot give instructions. So this is a question of delegation. Interesting. It's quite institutional. I don't know what the practical effect is, but it could be an interesting institutional discussion on delegation. Now, the fourth and last change I would like to mention, coming towards the end of my intervention, is the establishment of a controller of procedural guarantees, already also discussed before me. And it may be paradoxical to consider this as a strengthening of Olaf's position. But as the Olaf Supervisory Committee pointed out in its 2020 activity report, this new function could further reinforce public trust in Olaf's fraud prevention mission and tasks. So therefore, it's also kind of strengthening of its legitimacy. But the establishment of the controller is not just a matter of enhancing Olaf's legitimacy. I'm personally convinced it is also a response to a legal requirement resulting from the need to respect fundamental rights. Because for interference with fundamental rights to be justified, case law of the European Court of Human Rights, but also the EU courts, underline the need for adequate protection by the applicable legislation against arbitrary measures. So this protection implies that access to an independent authority must be guaranteed, which can control the interference with fundamental rights. This is an extremely, very important. So you don't have just to respect the fundamental rights, you have to create the framework of such a respect, and their independent control is extremely necessary, is extremely important. And this is precisely the kind of control which a controller is called upon to exercise. He or she is independent, including from Olaf, and he or she will examine complaints regarding Olaf's compliance with procedural guarantees and fundamental rights. Now, it's true that this intervention is not legally binding upon Olaf, because the competence of the controller is limited to giving recommendations to the Director General of Olaf. However, if the Director General decides not to follow the recommendation, he or she must communicate to the complainant and to the controller the main reasons for that decision. This transparency is a way of protecting a person against arbitrary measures, which is the ultimate goal of independent control of interference with fundamental rights. A further limitation I would like to mention is that the controller can only intervene if a complaint is lodged or if the Director General of Olaf requests the controller for an opinion. The controller cannot intervene on his or her own initiative. However, the complaint mechanism is in reality only effective insofar as the person concerned is aware of a possible violation of his or her procedural guarantees and/or fundamental rights. This is often not the case in situations which have an important impact on those guarantees, namely when Olaf decides not to inform a person of an investigation. How can somebody who is not informed of an investigation can file a complaint or decides to defer the right to be heard? Precisely in situations where control would be necessary, it could not be exercised unless the Director General takes the initiative of requesting the opinion of the controller. And there I would like to refer to the 2020 regulation, the fact that it explicitly mentions the decision to defer informing the person concerned as a reason for requesting the opinion of the controller by the Director General. I think it can be seen as an invitation to the Director General to precisely do so in a situation where the person concerned is not able to file a complaint because he doesn't know it. So I think it's not just the possibility of asking an opinion is not just some faculty for the Director General. It may be there necessarily I mean, in certain situations where a complaint is not possible because the person doesn't know it. To conclude this brief overview, the 2020 regulation has made Olaf ready to cooperate with the EPPO. It has strengthened Olaf's powers to the benefit of its own investigations, but also when Olaf conducts investigations for the EPPO to the benefit of the EPPO. And it has increased Olaf's legitimacy by establishing an independent control of Olaf's compliance with procedural guarantees and fundamental rights. I think Olaf is clearly fit for the future and in order to be an efficient connector, as Ernesto Bianchi said so illustratively yesterday. Thank you very much for your attention.
Grazie davvero anche.
Thank you so much, Ingram, for this wonderful presentation, which covers another aspect, the guarantee of fundamental rights, which at the end of the day, it's a guarantee to the right of for the defense. And internally, the legitimacy of institutions depend on the level of guarantees that they comply with, the level of compliance with privacy and the rights of the person, comply with the rights of the persons. I think this is of great interest. The legitimacy depends on the level of accountability, in the independence and the compliance with the rights of people who are subject to the investigation. So this is the most important principle, and we're very grateful to you for this approach in your presentation. That being said, are there any questions that you wish to ask of the various speakers? Well, Mrs. Kinichi has got to leave us, so we thank her very much for being with us this afternoon, but she has to go and catch a flight.
My name is Hans-Holger Hanford. I used to work for the German Ministry of Justice, and now I'm an interested pensioner living in Austria. I have one question, actually, and one comment to what Mr. Ingelram said, which I could also turn into a question to Diana. My first question is, you pointed out that the procedure for cooperation between Olaf and the EPPO is different from the traditional procedure in relation between Olaf and the national judicial authorities. The idea now clearly being that the Olaf should inform the EPPO without undue delay about any cases where there could be a criminal offense involved. My question is, what does that mean in practice? I mean, when you look at Olaf cases, can you see that when there's a smuggling event concerning Hungary, that Olaf would continue for longer periods of administrative investigations and then finally coming up with the usual recommendation. Whereas if the same thing would happen in Austria, you would quickly inform the EPPO and not continue administrative investigations for the time being. Can you say that that is really the difference, and where's the threshold? Because the EPPO regulation also says that Olaf may undertake preliminary evaluations of the allegations. So you need to draw the line somewhere of what is undue delay. In that context, another question to you: how do you deal with situations where you actually have a concurrent competence of a participating member, of a non-participating member state in the EPPO? I think Nicholas mentioned this morning investigations undertaken by Olaf at Frontex. I don't want to know anything about the details, but Frontex, of course, is in Poland in a non-participating member state. So you would at some point presumably undertake administrative investigations and then maybe come up with a judicial recommendation to Poland. However, let's assume that the suspect, the main suspect, is a German citizen. Then also the EPPO has a competence because Germany has a competence for German citizens, and the EPPO can undertake investigations also for national citizens of participating member states, even if they committed a crime in a non-participating member states. So how do you deal with those situations where you have two conflicting rules applicable of when to inform the competent authorities? Secondly, a remark to what Mr. Ingelram said, but in a way it is also leading perhaps to a question to you. Mr. Ingelram said that you alerted to the fact that when the EPPO, when Olaf conducts administrative investigations, how do you then apply Article 42, paragraph 1, and the competence of the national courts? I mean, when we negotiated the EPPO regulation, we specifically wrote into Article 101 that Olaf may conduct administrative investigations in a way that is obvious because Olaf can only do administrative investigations. But it was also worded that way to clarify that Olaf was not supposed to be a police judiciaire for the EPPO, so not in charge of undertaking criminal investigations for the EPPO. I think it would have been preferable when Olaf regulation was revised to clarify what that actually means, that Olaf can undertake administrative investigations on request of the EPPO. When we did the EPPO regulation, we simply referred to that, but it would have been preferable, I think, to clarify what it actually means. What kind of administrative investigations can Olaf actually take on request of the EPPO? We heard about the possibility to complement investigations by going after the money. But in that case, Olaf actually undertakes an own competence going after the money, and it is not a procedural act of the EPPO, which Olaf does by going after the money. And personally, I don't believe there are administrative investigations that Olaf can undertake on request of the EPPO, which would then be considered a procedural act of the EPPO. So therefore, I think the issue that Mr. Ingelram raised is an interesting question, but I don't think it should happen in practice because there should not be such administrative activities or actions of Olaf which would qualify as a procedural act of the EPPO. Thank you.
Grazie. Vedremo poi.
We'll see. I think I can say a couple of words and then I'll give the floor to the experts. I feel that we will have to look into the kind of agreement that will be entered into by Olaf and EPPO according to the article in the regulation. I think that this is the heart of the matter. Without a clear-cut definition and boundary lines between who does what, there is a definite risk of duplication, and hopefully there is no risk of entering into a conflict. Let's see what Diana has to say on that.
Interesting questions. I hope to have the answer to all, but I'm not pretty sure because, of course, this is very new for us. So these are issues that will surely come in practice. So we'll have to solve them when they will come, and we will have to interpret the rules in such a way as to make things working. So I hope I will have a theoretical answer, but I really would like to see also how this will happen in practice. So, with regard to your first question, so cooperation, Olaf, EPPO, in different member states, and how Olaf would inform EPPO. What I know is that now, for instance, when we have cases where we may have two different member states, let's say the example you gave, Hungary, Austria, and we discover that there is a criminal element, we just froze our cases. We froze them until we discuss the cases with the EPPO, and we agree who does what and how we split the work, if we transfer the whole case to the EPPO, if we take a part, or we just discontinue the investigation. So this is solved, I would say, on a practical basis, on a case-by-case basis, depending really on the concrete circumstances. So we just don't continue blindly. We stop, we discuss, and we take a decision. Then about the second question, you mentioned the example of Frontex. So Frontex, of course, this is an internal investigation, which means that of course, we first of all, what can Olaf recommend? It can recommend disciplinary action. It can recommend. I mean, I don't know absolutely nothing about this case, so I don't know what Olaf could recommend in such a case. But theoretically, so disciplinary action, or let's say if there is a judicial recommendation, what happens? Okay, Poland is not a participating member state, so the judicial recommendation goes to Polish authorities. So EPPO theoretically will not be involved in that part. But if, as you said, if there is a German national, again, I think that this will be decided on a case-by-case basis, discussing between Olaf, EPPO. So everything will depend on really the concrete circumstances. So I'm not sure that I will have an answer to this case, because you have already, I think we have already discussed that it's for me it's like a puzzle. We have to see which part is EPPO, which part is Olaf, which part is we can do in common, which part we can separate, how can we support EPPO? Of course, Olaf is not the judiciary police for the EPPO, but what I can give you as an example, so I will not reveal a secret, because in any case it will be published on our website. So you'll see in our new guidelines on investigation procedure, we make a clear distinction between what is support to the EPPO and what is investigation in support to the EPPO. I think it's a bit abstract now. Practice will show if the concepts are quite clear. But to make the distinction, support measure. So this would be Article 12E, I think, from the Olaf regulation. Support measure is something that Olaf will do for the EPPO without using investigative powers, meaning providing analysis, forensic information, but that's it, not investigation. So we will open a case, we'll do something for the EPPO, but will not use investigative powers. There is also the concept of investigations in support to the EPPO. This is new for us as well. So again, I think I've said it several times, we'll see how it will work in practice. But this will mean an investigation in which Olaf opens, an investigation open based on Article 5 of our regulation, but with the specific purpose of doing something for the EPPO, like going to do an on-the-spot check. So the result of this specific investigative measure will be also, will be reflected, let's say, I missed the correct English word, will be reflected in a final report, which will be sent to the EPPO, because it's something that we will do for the EPPO. So on one hand, we have support measures, non-investigative powers, investigations in support to the EPPO, but specifically for the EPPO. And these two categories are, of course, different from complementary investigations, which are investigations that we open to complement EPPO's activities. They will do criminal investigation. We do administrative investigations that will lead to the adoption of precautionary measures or disciplinary or recommendations or financial recommendations. So, of course, there is theoretically also a risk of overlapping, but I think the master word, the key word of the whole conference was cooperation, dialogue, consultation. So this, I hope, will allow solving the practical problems. We'll see. Thank you.
May I add something?
Grazie, sì, vediamo cosa ha.
Yes, let's also see what Mr. Jan Ingelham has to say.
Hear me?
You
can hear me?
Sì, sì, perfettamente.
Yeah. Okay, thank you. Thank you very much. I think this is a very interesting question on the possibility. It has always intrigued me, this possibility for Olaf to conduct investigations for the EPPO. Because the last, so the remark which was made, and a remark or question, should such investigations take place? I think it's a very practical question, because if you look, for example, you take a suspected corruption in a EU institution, the EPPO picks it up, but you need to know what happened, so you have to do a search in the institution. The EPPO will need a judicial authorization to do such a search. I mean, I'm not a criminal lawyer expert, but I suppose that's the case. Such a search done by national authorities on behalf of the EPPO, they will have the protocol on privileges and immunities. You may have to lift immunities and so on and so on. So this is quite difficult. Whereas Olaf just kicks in with a mandate. Nothing more than that. The Director General gives a mandate, opens the investigation, gives a mandate. So the difference, I mean, I think the temptation will be enormous if it is about investigations in the institutions. I don't talk about external investigations because there might perhaps be different, but in the investigations, internal investigations, the temptation might be enormous to ask Olaf to do the investigation, because there the framework is extremely light, also procedural guarantees. Therefore, I'm very happy that there's controller there, because then the level of the standard is lifted up for all of investigations. But I mean, I don't know whether this. I think there is this temptation there. I mean, I don't know whether Olaf would contradict it or hasn't thought about it. I don't know, but I see this as a risk, so that it. Olaf is used because it is very easy to do an investigation, and then, but that would amount to more or less circumventing obligations applicable to the EPPO, or could amount to that. So, voilà, thank you. But yeah, I leave it open. I mean, it's not.
Grazie, mi pare di capire.
Thank you. Following what you said, it seems that this is the moment to raise questions. The more questions we raise, the better. And then we will see what answers will come about. And this is a good approach to have good results. Questions are essential.
Thank you very much, Professor Wachmeier from Spain. Just entering into the discussion, because I think it's a very crucial one as regards the powers of Olaf in these investigations for the European Public Prosecutor, which if the aim was not to make Olaf as an agency like police judiciaire for the EPPO, so this is apparently in contradiction with that. Secondly, with regard to the words that we just heard about this on the most easy way to get into search of premises and seize documents under the Olaf administrative regulations, and then possibly use them for the EPPO proceedings, I think this is absolutely against the principles of criminal evidence and admissibility of evidence, because it's just circumventing the safeguards of collecting evidence by just using an open door in these investigations for the EPPO. At least to my mind, when there are measures which entail interference in human rights, in fundamental rights, like searches and seizure of documents and so forth, the privacy, I would say that would lead to inadmissible evidence in a criminal procedure, if not any other infringement, which would entail for law enforcement. And I think Olaf would be overstepping its mandate, even if it's provided like in the new regulation. I don't know. Thank you. And thank you for raising the question, Holger. Yes, of course.
Sì, pare di capire che a seguire un completamento.
Judge, you want to say something else? You want to add something?
To Orena's remarks. And to what you just said, if you have a situation where, for example, Hungary and Austria is connected to potential criminal activity, when you detect criminal activity, your mandate ends, and you freeze the cases. That's fine, and you consult EPPO concerning Austria. That's fine, but then you should also consult Hungary, because that's Hungarian criminal jurisdiction. And that's outside of EPPO field, but it's outside of Olaf's mandate. So criminal activity belongs to those authorities who have a license to deal with criminal activities. That's one point. Another point is that I don't think that a sane prosecutor would opt for an administrative investigation and an on-spot check instead of a criminal procedure measure like a house search and seizure according to the criminal procedure rules. So I can't really imagine any, at all, a situation where an administrative procedure could take precedent over criminal procedural measures. So this second option of, I'm very much convinced about the supportive steps, non-investigative steps taken by Olaf in support to EPPO or other member states' procedures. That's fine. But I can't imagine any situation where additional procedural steps could be more favorable from the point of view of a criminal procedure and admissibility of evidence than those which can be taken by those law enforcement agencies which have the mandate to investigate in criminal procedure. So this is just my opinion. Thank you.
Grazie. Mi pare di capire.
Thank you. If I am getting it right, it seems to me, and I'm intrigued by this problem because it is a problem of the applicability to domestic law, and in the Italian case, this would lead to a principle of the illegality of the evidence, which would have a huge impact on criminal proceedings. It seems to me that what you're saying is vis-a-vis an offense, the administrative phase must be suspended and all the work to collect the evidence should be the exclusive competence of EPPO. I have no doubt on this, but I think this could be matched with a role of Olaf different to the phase of collecting the evidence or of confiscating records, and it is the competent prosecutor, to say it in the Italian way, that needs to have to do this. But something different is to imagine that Olaf already has a set of documents available, and I don't see the harm of transferring, if there would be a harm in the transfer of such documents to the EPPO. I hope I understood correctly. I would also kindly ask to our colleague Andrea Venegoni to come to the podium, as he will be drawing the conclusions of the conference. I see he was sitting just on a chair rather uncomfortably, so I think he can come to the podium.
Passing the word to Andrea. I am trying to address both the comments from Lorena and Balázs, with which I fully agree. I was also, I can say as a personal reflection, that when I first read the regulation, I was quite puzzled by some of the provisions, starting with this new Article 12E, which is about support to the EPPO. Of course, again, we'll see how it will work in practice. But when we look at the theoretical aspect, for me, it's there is also the counterpart. Okay, Olaf can conduct support. I mean, can provide support to the EPPO, including by conducting investigations. But there is a limitation to this, and this limitation is very clear in this article. Olaf will have to comply with the procedural guarantees which are set out in Chapter 6 of the EPPO regulation. So Olaf will be obliged to respect those rules. So in principle, if all the rules are respected, the measures carried out by Olaf and which will be reflected in documents like final reports or another type of documents will be. Sorry. So this will be.
Okay, there was a bit of an echo effect because of the headsets. This should be resolved now.
Okay. Thank you. Okay, not using the headset anymore. So I was saying, in principle, if these rules are respected, so the procedural safeguards of the EPPO regulation, in principle, this Olaf reports should be admissible. Again, we'll see. The practice will show us. And I will just refer to the fact that this article, if I remember well, I don't have the text in front of my eyes, but I think there are 3 categories of what means support to the EPPO. The first is providing information, analysis, expert analysis, something like this. The second point was, if I remember well, to provide, to coordinate activities of national administrative authorities. So this would be the kind of support measures which do not require investigative powers. And these are embedded in our guidelines under this category, new category, which is support cases. And the third point, I think it's point C of this article, is the power to conduct investigations in support to the EPPO. So this is, I think, the category which is most, let's say, problematic. But again, the same procedural safeguards would apply. So I would imagine that if Olaf investigation is conducted in compliance with these procedural safeguards, it's everything should be fine. But we'll see. And just a last comment about this. What you said, the example Hungary, Austria. Again, of course, the limitation is there in the regulation. Olaf cannot conduct a criminal investigation. So if there is a criminal element, it sends it to the EPPO. If EPPO is not competent because the case, I mean, there is something linked to a member state which does not participate in the EPPO. Olaf has another means, and this means is to do judicial recommendations. So of course, Olaf will set up will set up its findings in the final report, and will recommend a judicial follow-up, but not more. And this is what we have done until now for years. Yeah. So I think, of course, there is always a balance to be found. And in practice, I think the difficulty would be exactly to know what to do. Split the case, send everything to the EPPO, send parts to different judicial authorities. We'll see. Thank you. Yeah.
Grazie.
Thank you. If there are no other questions,
Thanks a lot, actually. Ingrid Marshall-Clausen, European prosecutor coming from Austria, as Austria has been mentioned a couple of times. Now, I think what will happen in practice, coming to Hans-Holger's example, is that as soon as Olaf has any suspicion that a criminal offense affecting the EU's budget has been committed, Olaf will inform the EPPO. And I can confirm that in each single case where there has been an Olaf information to the EPPO, there has been the offer from the Olaf side to discuss the case sort of bilaterally, in depth, the EDP in charge with the Olaf investigators to see what fits best for the individual case. Now, coming back to Hans-Holger's example, actually, the EPPO will, as we know, will have to initiate a criminal investigation immediately. And at some point, if the suspicion gets clearer and is more reinforced, the EPPO will have to conduct house searches within Frontex, meaning, as obviously Poland is not part of the EPPO, or not a participating member state in the EPPO, you said it is a German citizen. Actually, we would have a German handling EDP. The German handling EDP would send a European investigation order to Poland. And then the Polish authorities hopefully would execute the house search. And then we're in the situation where we are already now in cross-border contacts between EU member states. Either the Polish authorities, on the basis of the results of the house searches, by their own accord, start initiate an investigation, which would be a criminal investigation then Olaf can support. Or if not, the German EDP would, I guess, do what I have done when I was a prosecutor in Austria, notably send the material officially if the Polish authorities do not analyze the seized material and send it back. I would send the analyzed material to the Polish authorities, and I assume that's what the German EDP will do, with the request to consider whether they have, in accordance with the Polish legislation, to initiate domestic proceedings. Now, there you go. So I don't think that actually in reality we would end up with Olaf continuing administrative investigations without the Polish judicial authorities knowing all of that. I don't think that this is going to happen. And a small remark from my former professional life as national member for Eurojust. Actually, I on behalf of the Austrian judicial authorities at the time, had to coordinate in an investigation against a former member of the European Parliament who was forced by his political party to step down from his mandate. I had to coordinate house searches in the premises of the European Parliament in Brussels and in Strasbourg. And upon request by, at that time, my national prosecutor in charge of the case, we managed to get Olaf into the team conducting the house search in the premises, because my national prosecutor said, I don't know anything about the server of the European Parliament. Olaf will know. I don't know anything about the setup of the offices in the European Parliament. Olaf will know. So I can very well imagine that this type of support by Olaf is valuable and will be applied in practice also by EPPO investigations and in EPPO investigations. Thanks.
Grazie, quindi più che una domanda, delle considerazioni.
Thank you very much. I think you've made very relevant comments, very consistent with the provisions contained in Article 12, quarter para 1 and 2 of the new regulation. Not only do they refer to the need to, with undue delay on the part of Olaf, to report about possible criminal relevance. Well, it has to sort of also provide all the available information as to the possible victims, the suspects, and so I don't think that it refers to just a limited role, but the role of an authority that has its own know-how, that provides information about an offense or a crime, which is as detailed as possible, which is clearly an indication of the relation of very clear collaboration, which is being indicated in the new part of the regulation. So this brings us back to Article 12 of that will indeed provide for a very precise agreement between EPPO and Olaf. If there are no further questions, I'll give the floor to my colleague, Andrea Venigoni, who'll draw this meeting to a close, and he'll draw conclusions in his capacity of former member of Olaf. And if ever he will become the general prosecutor of my office at the Court of Cassation, he will be responsible for dealing with EPPO problems at the level of the Cassation Court. And we cannot talk about that right now. Thank you. Let's keep our fingers crossed. So when that won't happen, I won't have to do that. Well, the beginning of this sort of final comments to wrap up this meeting. We'll start with words of thanks for the Fondazione Basso that has once again managed to organize a very relevant conference on this topic. The only comment which I'd like to add on that even though the topic is of great interest, we don't manage to get to sort of a large audience also because of the pandemic in this case. However, we do have the impression that we sort of have our own private dialogue on these matters. In the meeting that we've had 5 years ago or 3 years ago, we were more or less meeting with the same people here, and that is rather discouraging, because if I could give you in a nutshell what was said on this theme, the word that came to mind for me is the liveliness of this debate. So we've been shown that this area of the law, which where criminal law in EU law are intertwined, and we could also talk in terms of European EU criminal law, if you like, is one of the liveliest areas of both criminal law, penal law, and the EU law. So it should be very attractive and attract lawyers and magistrates and young scholars. In addition to that, we have seen the greatest sort of breakthrough with the establishment of EPPO that, as the Chief Prosecutor Covesi told us, is unprecedented, never existed any such a body. It's not a new coordination body established within the European Union, but it is a body that is entrusted with the conduct of specific criminal investigations in an area which comprises 22 countries that are member countries of the EPPO and which are combined in a single office. We cannot talk in terms of a single legal area, but there is a single office which is in charge. Another point of great interest, which was also emphasized by the deputy chair of the Higher Council for the Judiciary, is that the beginning of work done by work undertaken by EPPO coincides with a very special time when many European countries, Italy amongst them, are being granted considerable amount of funding from the European Union, which are part of the financial interest of the European Union, even though they are not part of the budget of the EU stricto sensu, but can be covered by the general notion of financial interest of the EU. So now EPPO is up and running and can get down to sort of dealing with possible frauds in the use of this funding, so which come within the remit of EPPO. A further reason that we have to get to know better what EPPO is doing was emphasized by President Ippolito. We could say that EPPO does represent the more sort of unionist approach in the European Union. We know that there are two approaches, the intergovernmental approach and the unionist approach. The establishment of EPPO, which has not been established fully according to the proposal put forward by the European Commission, is certainly a step forward in the path towards integration. So I'm sorry that we haven't had a large audience listening to this debate in this area, which is of fundamental importance, the protection of financial interest, as Mrs. Kenichi told us. It's a testing ground for the creation of a common area of justice, even criminal justice within the EU. And this is a process which is not starting today. Well, today we have EPPO and people seem to discover that it exists now, but we're talking in terms of an institution which is basically being preceded by work and discussions which have been held for 20 years, if not more. So this area that covers the financial interest of the Union is the number one sector in terms of creating the creation of an area of criminal justice in Europe. If we'll achieve that, this will be achieved quite definitely in this area. We have talked about the various categories of frauds. Mrs. Holmeyer told us that frauds can be very complex and sophisticated, which demand a specific knowledge to be evaluated and which concern a specific area, European area. The many interests which are covered by the Union, there is a typically supranational and European interest, as Fabio Gioffrida said, is certainly represented by the financial interests of the Union. We have understood, and this was mentioned by Mr. Bianchi from Olaf, fraudsters in this area have become more and more sophisticated, and this demands a more specific and comprehensive answer on the part of the fiscal police. We've had General Cuneo from the Guardia di Finanza, the fiscal police we have in Italy, who explain how they're getting ready for it. This type of frauds require human and technical resources, which should be appropriate and sufficient. We've learned from the comments given by the Dr. Lashuk from the Court of Auditors that we have to further fine-tune the communication mechanism. We've heard people talk about the relationship between EPPO, Olaf, and the Court of Auditors, European Court of Auditors. So we have to move forward in that respect. We've also heard important comments on EPPO, substantive rules, the PIF directive, and the question of the relationship with Olaf. In connection with this last point, I would say that we talked about the relationship with the body, which is not mentioned under Article 86 of the Treaty on the Functioning of the European Union, the body which is quoted in Article 86 with respect to the relationship with Olaf is Eurojust and not Olaf. But whoever deals with this type of questions for many years is well aware that one of the crucial point for EPPO work was not just the relationship with Eurojust, but far more the relationship with Olaf. That who is conducting actual investigations in the same area which is covered by EPPO used to be Olaf, while Eurojust act at a coordinating body. Now, as to the PIF directive in this session coordinated by Katalin Ligeti, we've learned the problems in the adoption of the directive at European level, at a national level. At European level, Lorenzo Salazar has mentioned a very thorny problem of the legal basis. We've been talking about this for years. Well, after attending this meeting, what comes to mind is to consider what would be the scenario, the protection of financial interest, where sort of the basis, the legal basis, be the Article 325. I dealt with the draft directive at the time, and we had written that the legal basis was 325, and someone suggested that there would be a possibility to have a regulation rather than a directive, because the 325 doesn't sort of envisage specific constraint, formal constraint. So this is something which I'm still considering, because in the near future there won't be a new law that will deal with the new substantive law. So the question whether the PIF directive was a missed opportunity or not is quite justified. By the same token, Professor Sicurella said that we should ask the same question with respect to transposition rules that Italy has adopted. It might have been another missed opportunity. We could have redefined new rules, but we have simply confined ourselves to transposing the European rules with all the problems that it has entailed. For instance, the problem of attempt in tax-related crimes. We have to deal with that because that is covered by the PIF directive, and the implementing legislation, enabling legislation has to include it, but it wasn't done in an orderly manner with respect to the tax-related crimes and offenses. This might raise some problems of constitutionality. We do have VAT rules for some VAT-related frauds for direct taxes, whilst for direct taxes we have a different set of rules, and the same has to do with the accountability of entities. Well, so we're still up against some problems in the way in which this has been taken on board in the current legislation. But this might create problems in terms of how we can identify jurisdiction. This is a very delicate issue, and the mechanism envisaged within EPPO for the choice of delegated prosecutors, which is the jurisdiction where the criminal action will be, proceedings will be taken. Well, this aspect of EPPO functioning is a delicate aspect that, well, the defense will have to cope with. But I will look, on the other hand, to some other aspect. It is a mechanism which allows to keep a united sort of investigation rather than a fragmented investigation. I do recall, because what happened in 2012, I wrote an article well, some strong grounds for the establishment of a European Public Prosecutor's Office, and this was based on a case of agricultural fraud that Olaf had that concerned Bulgaria and Germany, which in Germany led to the conviction of all the sort of perpetrators that were sort of tried in Germany. In Bulgaria, they were acquitted. They were all acquitted for complicity. They were accused of complicity, but they were acquitted. Well, in the earlier scenario, this possible danger of fragmentation, a different outcome for the same conduct, was a real risk, an actual risk. There were problems of transferring the evidence from one jurisdiction to another. Possibly in Bulgaria, some of the evidence collected in Germany could not be used. EPPO hasn't fully settled this problem. True, but the investigation can be a single investigation. So even though I'm aware of the fact that this is a delicate point, I would say that there are some positive implications in what has been achieved. We talked about problems related to the functioning of EPPO. This does not depend on the rules. Well, it partly may be the interpretation of some rules, but to a large extent it depends on the historical stage on which we are discussing. This is completely new ground. We have to break new ground, and we have to create the practices which did not exist in the past. As to what was said by Lorena Battmeyer, who presided over one session, She said that there are a number of legal problems. Luca De Matteis gave us an overview of the various legal problems, inherent legal problems, but also some practical difficulties. Danilo Ceccarelli talked about how delegated prosecutor, European prosecutor, should be organized. He talked about how they are organized in Italy, but he also referred to other countries. This is a practical aspect that has a considerable impact. Ingrid talked about the organization of the chambers. And another point, which he felt was very controversial, of how the work had to be allocated to the various European prosecutors to ensure the sort of more or less the same workload for all of them, to ensure that a European prosecutor that has only a few cases at central level doesn't work at all. Whilst there is a decentralized level, there is an over the delegated prosecutors are overworked. Thomas Krushna talked about the dialogue with the national authorities in the framework of the European institutions which are interacting with the EPPO. So the EPPO does have a political responsibility vis-à-vis the European Parliament, which shouldn't, however, undermine EPPO independence. And we've heard that the most controversial and delicate issue has to do with the EPPO staff, namely the possibility of having disciplinary procedures. One has got to be very careful about disciplinary procedures because they may be sort of indirectly affect the operational efficiency of EPPO. With the session presided over President Birriteri, we talked about a relationship between EPPO and Olaf. Despite the treaty quotes Eurojust, we have devoted a whole session and we could have a whole conference on the relationship between EPPO and Olaf. As a former member of Olaf, the impression I have is that as we had somehow anticipated, Olaf doesn't know exactly where it stands with respect to EPPO. Now we do have this new regulation that tries to sort of settle some problems, but there are some other aspects which are still very delicate ones. And this is something that was mentioned also when EPPO did not exist and we were only dealing with national authorities. We can exclude that Olaf acts as a European judiciary police working for EPPO. We can exclude that possibility because if we wanted to achieve that, well, the Commission proposal would have been taken on board, and the Commission proposal envisaged a central level, some 40 prosecutors that could have been sort of carrying out investigations for EPPO overseen by the central level. And the central office had the possibility of conducting investigation. The Commission proposal of the time was not taken on board, and Olaf has a limited power to conduct investigation. In the regulation, it is said that EPPO uses the judiciary police of the individual member states where the investigation should take place. So we can't assume that Olaf acts as judiciary police. Olaf will pursue its work in carrying out administrative investigations, which have a more limited scope with respect to what happened in the past. When the judiciary counterpart were the national sort of judiciary authorities. There was a fragmentation of the reference authority. The National Judiciary Authority were dealing with their own criminal proceedings, not just community frauds, EU frauds. They were a limited portion of the national proceedings. So Olaf was the only office which was supposed to conduct administrative investigations in this area, had a raison d'etre, and could sort of stimulate the judiciary authorities that weren't so eager to conduct such investigations for a number of reasons, obviously. Sometimes the investigations are not considered by the member states as very urgent. While a public prosecutor or the law enforcement focuses on other kind of crimes, but Olaf at the time has its own raison d'etre and a clear identity. Today, that we have a judiciary authority that only deals with these crimes, it's the only one that deals with these crimes and has a sort of a scope which is similar to that of Olaf. The impression I get is that Olaf has to reposition itself in the studies that were made in preparation of the drafting of the regulation. Some felt that Olaf at some point should no longer be there with the establishment of EPPO. The regulation had not envisaged a discontinuation of the Olaf, the anti-fraud office, but there is a practical risk of overlap. Olaf's activity will sort of still include the question of the transfer of evidence from the administrative level to the criminal level, and that has to do with EPPO. We've got to be very careful because the transfer of evidence from the administrative level to the criminal level, it's a very delicate one. That guarantees are not the same, even though the Olaf regulation has gradually sort of achieved the traits of the guarantees envisaged for criminal investigations. So if I have to have an administrative investigation that has more or less the same guarantees of a criminal investigation, it would be far better to have sort of the criminal investigation rather than having a two-tier system. Well, actually, I'm quite happy that Olaf is up and running, and I'm still very close to it and its work and its raison d'etre still exists for those investigations concerning member states that do not belong to EPPO, for investigations with countries of the European Union that are not part of the EPPO, but were also for third countries. Dr. Bianchi mentioned customs-related investigation. This is something which is not covered very often, but this is very important work. So the possibility that Olaf has to obtain evidence from faraway countries which go beyond the legal framework of the European Union, but still a major sort of value added. This is represented by investigations where Olaf would have to use letters rogatory to get the necessary evidence. So Olaf, as I said, is still very useful, playing a useful role, even though the problem of trial guarantees is still standing. And this is something that will be sort of settled in time. There should be a specific agreement to that effect between EPPO and Olaf. Well, for a suspect which is under investigation, sort of. This is a very delicate issue, the transfer of evidence, because the person who is object of the investigation has to cope with what is being done in the investigation. Well, I have the impression that there is a lot which is happening. So we are going through a very interesting stage in this process, in the evolution of the EU criminal law. And there will be future developments to that, of course. Well, there are a number of issues that still have to be clarified, and have a personal recollection which I'd like to share with you on that. This is a special sort of date for me because it's a 30th year that I've been working for the judiciary. So the 7th and the 8th of October were the days when I first sort of acted as in a judiciary office. If I had been told at that time, 30 years ago, that today we would have been involved in discussing the European Public Prosecutor's Office, which had been established, I would have never believed that. 30 years later, we are discussing about something which is up and running and exists, EPPO. So this is something that should be given great value. As I said, we are halfway along the road. There's a long way to go, but there's something which I say normally when I go to conferences of this nature, even before lawyers. I don't know whether if we want to solve many of the problems, it wouldn't be better to assume that there will be sort of a core number of criminal rules, EU level. I wouldn't talk in terms of a code of criminal procedure at the EU level, but also for the guarantees of those who are under investigation. If we had a common core of rules, of criminal rules, would be better. So even in this specific area of the protection of financial interest, would enable us to create a common area for criminal justice, something which is something where we are hope to achieve. We'll see what will happen in the future, and hopefully we will meet again on another occasion. I was asked to give you some practical indications before we say farewell, and we draw this to a close. There is a farewell coffee which is being served in the courtyard where we had lunch. So I thank you, and that draws the meeting to a close.